40?
43 Lordship.
43 is some Lekhan Upadhyay.
23 Lordship.
Huh? 2-3. Oh, that.
I've taken Lordship from my learned friend. Lordship, due to 50% of the strength of the university has been engaged in the election duty. So there is nobody to carry out the record.
That is recent, Mr.
Yes.
That
Order
was
of
only the other day.
12-2.
No.
Order.
My order, I think, is
12-2.
Yes, Lordship.
12-2, my lord.
Yes. Lordship, recently, after in the last week of the all the employees, Lordship may fix on 4th of April, Lordship. Fourth of April, Lordship.
What do you say, Mr. Arnab?
My lord, speechless.
We should also understand his problem. What can he do?
Yes. That's why I'm leaving it alone.
On the prayer made on behalf of Mr. SCKL, Learned Standing Council, Assam University. Item number 23. List this matter again on 4/4/2024. By the next date fixed, the affidavit as requisite as required by this court-wide order dated
12-2.
12/2/2024 shall invariably be filed by the university authorities, failing which appropriate orders as may be called for would be passed.
Lordship, same
Obliged.
with respect to item number 38, 39, and 50.
My lord, here also records belong. Last time also time was short, my lord. Last chance may be given, no further chance, my lord.
Here, only thing you wanted, what we wanted you to do
Records.
was find from the records, just, you had the records with you.
Non Lordship, they have taken back, Lordship. On 4th, Lordship, on the same day, Lordship.
Two heavyweights, can this court bear two heavyweights, Mr. Chaudhary, Mr. Nath and Mr. Kayal, together, two cases, it will be too taxing. Anyway, on the prayer made on behalf of Mr. S.C. Kayal, same, Standing Council so and so, list this matters again on 4/4/2024.
Lordship.
On the next date fixed, Mr. Kayal shall invariably comply with the directions passed by this court by its earlier orders, by the earlier orders. Also,
Much
Item number 1, my lord. Item number 1, my lord. This may be at 2, my lord. I have one PC matter in item number 20, my lord. At 2. Yes, my lord.
no problem.
May I please also? Well, this matter will be listed on Friday, my lord.
What is it?
One of the fixation of scale, one of the now in the value of it.
May I please the lord.
May I please your lordship?
May I please, your lordship? Lordship, I beg to mention item number 19 of the daily list, lordship.
Why?
Lordship may not like to take up this matter, lordship.
Oh, you, I cannot.
Lordship, but there is some urgency, lordship. Lordship may fix it on Friday, lordship.
List before any other bench without me. Naam to likhi dibo. The petition, counsel for the petitioner expresses urgency accordingly, the registry to take steps for listing of the matter again on
Friday, lordship.
19 no. 15 no, 22 3/2024.
Lordship, deeply obliged, lordship.
May it please your lordship,
Hmm.
with the concern of the adversary, I beg to mention item number 26, lordship. My senior is out of session, lordship. Kindly fix the matter after 1 week.
20
29, lordship. 29.
on the prayer made on behalf of Mr. R. Dubey, Learned Counsel for the petitioner, list this matter again after 2 weeks on a date to be fixed by the registry.
May I please your lordship? I beg to mention for a listing and a writ petition 784/2024. Okay.
May I please, your lordship? Lordship, I beg to mention item number 2. Also, I am appearing on behalf of Mr. N.N. Upadhyay, lordship. So I want to withdraw this case, your lordship. As per the instruction of the petitioner, sir.
Rightly so. What is there? 1 paragraph allegation. 2 paragraphs in the affidavit dealing with that. Finished. Okay. Your name?
S. Sharma. S. Sharma.
Mr. S. Sharma, appearing on behalf of Mr. N.N. Upadhyay, submits that he is under instructions from the petitioner to not press the matter any further. So accordingly, the writ petition stands dismissed as withdrawn.
May I please your lordship?
Hmm.
My lord, I have prayer for listing of an IM, my lord.
for vacating the interim order, my lord.
Next week,
Lordship will kindly bear with me, my lord. By suppressing the material facts and records, my lord, this interim order was obtained, my lord.
Friday.
Friday, my lord. Hello, my lord.
Wait, previous your lordship, lordship has begged to mention for listing of a contempt case, your lordship. Obliged.
May I please, your lordship, beg to mention for listing.
Any listing, give it.
Yes.
May I please, Lordship, beg to mention item 21, Lordship. Mr. Fuya, counsel for applicant is out of station, Lordship.
Hmm?
Item 21,
You are making a prayer on behalf of?
applicant, Lordship.
Why?
To actually engage counsel, Mr. Fuya is out of station.
Huh?
Mr. Fuya is out of station, counsel for applicant.
Next time, such matters, if you don't give a note earlier day, I'm not going to adjourn, subject to the council being not well in the morning.
Obliged.
We'll not permit.
Apologies,
We
Lordship.
come, we spend time.
My apologies, Lordship.
We'll have it on Friday. Friday, location. 21 to, on the prayer made on behalf of the, you have informed the petitioner?
Petitioner not informed actually.
Then why do you make a mention? Egundi likha. No adjournment. Call it when it comes.
My lord, item number 51. This is a contempt case.
Hmm,
The director has passed the speaking order as directed by this honorable court.
hmm.
On 10/10/2023, that is also, we have challenged that order, your lordship has set aside that order. So contempt may be prohibited.
Item number 51, Mr. N. Sharma, learned counsel for the petitioner, submits that the order violation of which was alleged in the petition has
On 10/10/2023.
since been complied with. So accordingly, the contempt petition stands closed.
May I please, the lordship? Well, item 32, my lord.
Item
32. I have taken consent from the other side, my lord. Let the matter taken after 1 week, my lord. Due to some unavoidable circumstance, file has been misplaced, my lord.
I'll give you the file.
File has been-
I'll give you the facts. I'll give you the facts. I'll give you the file. You just tell me.
On the other hand, they have not.
That second file, give it to
On
me.
other hand, my lord, they have not also yet filed any affidavit.
Forget the affidavit. Forget the affidavit.
Regarding provincialization of LP school, my lord.
That's what I'm saying.
After 1 week,
Here, DSC has recommended your case.
my lord,
District Scrutiny Committee has recommended your case. Thereafter, they have not taken up the matter.
taken.
What is left? You'll direct them to take the matter forward. That's all. You approach the Director of Elementary. Why
Yes,
keep
yes,
this
yes.
matters pending?
Yes, then okay, my lord.
Can any better order be passed?
Yes, that's,
Huh?
then okay, my lord.
You
I'll
take the second file,
Yes, yes.
SST code.
Yes, yes.
Top of the list, item 3.
Yes.
Lordship, matter may be passed over for the time being, Lordship.
Where is he?
Code number 24, Lordship on legs.
Let him be. You be here. Yes.
May I please, your lordship? My lord,
Now tell me first, question first, maintainability.
my lord,
Maintainability.
maintainability, my lord.
Show me what cause of action has arisen within the jurisdiction of this court. That much only.
My lord,
You were appointed in Imphal, selected in Imphal. The services were terminated in Imphal.
my lord,
What can we do here? Why should we interfere?
my lord, I have, in my reply affidavit, my lord,
Hmm.
I have already stated the maintainability, regarding the maintainability of this at para 3, my lord.
Hmm.
May I read, my lord?
This is not a ground.
And
This is not a
secondly,
ground.
secondly, my lord, I have relied on judgment of the constitution bench, my lord,
Yeah, show me.
regarding the maintainability, my lord. This court have a jurisdiction to entertain my petition, my lord.
Show me.
My lord. Hajur Singh versus Union of India, my lord. AIN 61 SC 530. Madam, one minute. At para 11, my lord, Hajur Singh, my lord.
Then,
I have filed this petition against the Union of India, my lord. And CRPF have every, my lord, units in the Guwahati also, my lord, and in their affidavit also, they have filed from Guwahati. In Producing's case, my lord, your lordship may kindly peruse the 11, 12, 13, 15, and 16, my lord.
para,
There are 11, 12, 13, 15, and 16, my lord. May I read, my lord? Para 11, my lord. The two main questions here arise therefore are whether the.
just a moment, just a moment. Okay, we got it. Now you tell me, when the order was passed, where were you? When the order was passed, where were you? You were in Imphal?
Yes, my lord.
That-
But subsequently, I have come down to.
Subsequently, you may have come here, you may have even gone to Andaman, may have gone to West Bengal, may have gone to Patna, may have gone to Maharashtra.
But
But
his,
will the jurisdiction, wherever you wish, will it be instituted there? Sorry, it will not be.
my.
Because we don't have anything here. In these cases, those persons were staying at a particular place. From another place, an order was issued. Then the Supreme Court said, okay, you can interfere. And on merits, what do you have to say?
In fact, my lord, by that time, my lord, when I have filed this petition, my lord,
Hmm.
in the year 2014, my lord, only 6 months prior to this, my lord, Manipur High Court was established, my lord. But otherwise, my lord, there is a circuit bench from our High Court, my lord.
Even if it was not a circuit bench, it was a permanent bench.
Permanent bench, my lord, from 2013. my
So
lord.
any matter here, if you have to file, you will have to take a permission from the Chief Justice. Why?
Because,
Okay.
because, my lord.
Okay, we'll come back to
my
we'll hear
lord,
Mr. Chaudhary also on that.
My
But
lord,
just tell me
CRPF
one thing. Mr. Alam, tell me one thing. What do you have to say on merits?
In fact, my lord, I was illegally terminated, my lord, without hearing.
You were having 3
Since-
cases pending against you. 2 cases before you joined service was you were acquitted for lack of evidence. Nobody came. And in the charge sheet, you will find, in the judgment, you will find a statement of the IO that nobody is coming up against these gangsters. That's the statement, be that as it may. The 3rd case was pending.
No, my lord, that case is already disposed of. I have annexed.
Disposed of after you joined service.
After the, my lord. That's true, my lord.
So why did you not disclose that?
That possibly, my lord, in fact, my lord, if they have asked me, in that case. my
No,
lord,
no, when they give you that form,
Yes, my lord.
attestation form, you will have to, there is a clause. whether you are involved in any criminal case. FIR is of 2006
My lord, that's true, my lord. That's
and
why-
I have
that's why-
scanned your whole pleadings and I have not found a statement that you were not aware of that proceedings.
In that case, my lord, the FIR was filed in the year 2006, my lord, and I was appointed after this, my lord. By that time, my lord, matter is pending subsidiaries before the court, my lord.
Yes,
In
you
the
could have,
meantime,
why did you not declare that?
In the meantime, my lord, two cases, my lord, have been closed off in the
I am
year
only
2008,
concerned
my
with
lord.
FIR number 15206.
That was only that was pending. Otherwise, other two matters, my lord.
Other two, we are not concerned. Other two, even if you are not disclosed, we will not be holding against you. But why did you not disclose the third one? Which was the case pending against you?
That in fact, my lord, in that case, my lord, I was not arrested even, my lord. And subsequently, so far as my
That we will not
information,
permit you because you have
And-
not brought that on record and the contents of the judgment shows that you were aware.
matter is pending since 2006, my lord.
Fine.
In event that, my lord, I was appointed, but they have at least, my lord, about the termination, my lord. They
Show me a judgment that such non-disclosure would not be held against you.
At least preliminary report, my lord. I'm entitled for that. Also.
You were terminated under the provisions of the temporary, sir. Yes, they cannot proceed against you under the 27 because this is not an act after you join the service. This was something prior. If it is prior, then the CCA rules will come. We will have it at 2. Find some judgments in your favor.
Otherwise, my lord, if your lordship allow me, since my lord just prepared it tomorrow, yesterday, my lord. So one day or
No, today itself.
tomorrow, my lord.
No, today.
Okay.
2 o'clock. 2 o'clock.
Item 4,
Lordship, 4 also time, pass over for the time being, Lordship.
Lordship, once again, my lord, lordship, whether case will survive or not, my lord, that your lordship has to see. Annexure 2, my lord, my lord, the age limit was.
Your age limit is gone. Secondly, the review board, you have referred to the Guwahati Medical College report. The Guwahati Medical College in its own way has said that you are having varicose on your right leg.
Right.
So that was upheld by the review medical board. Now, for civilian job, there is no problem.
My lord, that is true, my
But
lord.
if it is BSF, their standards would be high and this court will not come in.
My lord, apart from that, my lord, since.
Age is gone.
Age is gone, my
So
lord.
we withdraw it.
Lordship can close, my lord, infractions, that will do, my lord.
You make a prayer. Mr. J.I. Borbia, learned counsel for the petitioner submits.
Lordship, can you highlight, my lord, the age limitation?
The petitioner, during the pendency of the present proceedings, has become overaged for recruitment to the service,
BSF Constable Cook.
to the service in question. Full stop. Accordingly, he prays that the writ petition be closed as having become infructuous. Full stop. Prayer accepted. The writ petition stands closed as having become infructuous.
Lord.
Otherwise, also, Mr.
Yes,
Praveen,
my
there
lord,
is nothing.
because I do not have the age. That is the
The age
problem.
also, even if this writ petition would have been allowed, you would have come in. But still, you cannot come in because of that.
item 5,
No further order is called for. I to silence. I is there supposed to? In view of the order passed in the writ petition, no further order is called for.
May I please order?
Yes, Mr. Goswami.
Lordship, order under silence, page number 38. Lordship. Decision.
You have the act with you? Have the act regulations with you?
Oblige, order. This is the regulation.
You take it out.
This dismissal on the order under
48.
48 of the life insurance professional staff regulation 96. My argument is regarding 3 or 4 points, mainly regarding the whether that
You can come to the Provision 48.
Review. Notwithstanding anything contained in this regulation, the corporation may, on its own motion or otherwise, after calling for the records of the case, review any order which is made or is appealable under this regulation, and confirm, modify, or set aside the order, impose any penalty or set aside, reduce, confirm, or enhance the penalty imposed by the order. C, remit the case to the authority which made the order or to any order authority directing such further action or inquiry as it's considered proper in the circumstances of the case, or pass such orders as it deemed fit, provided that an order imposing or enhancing a penalty shall not be passed unless the person concerned has been given an opportunity of making any representations which he may wish to make against such enhanced penalty.
Mr. Goswami, what we understand here is the power is solely vested in the board. The board may call for and on its own review it. And if it finds, yes, it mandates, it will issue a notice to the concerned person and thereafter proceed with the penalty. Now, what is your argument on that?
My argument starts from the point of so cause notice regarding the enhancement of penalty. This is
Page?
so cause notice, page 36.
Hmm.
So cause notice itself for the paragraph number first, second, third, fourth, fifth, fifth para, page number 36, annexure 9. And whereas the corporation in exercise of its power vested under regulation 48(1), after calling for the record of the case and reviewing the order passed by the disciplinary authority in its 556th meeting held on 23rd 1/2023, observed that the penalty of reduction of basic pay by 5 stages in the time scale applicable to him imposed on Sri Gogoi by final order dated 26/2012 was not commensurated with the gravity of the misconduct committed by him. Second important para, and whereas the corporation in exercise of its power vested under regulation 48(1)(b) resolve to enhance the penalty of reduction in basic pay by 5 stages in time scale applicable to him imposed by the disciplinary authority in terms of regulation 39(1)(d) on Sri D.P. Gogoi to the penalty of dismissal in terms of regulation 39(1)(g) of LIC of India Staff Regulation 1960. This paragraph, the decision already been taken by the corporation in board 56th board meeting without hearing me, without giving an opportunity to me to place my case. Board already be taken decision to dismiss me from my service. Predetermined notice sent to me. That is first thing. Already been determined by the board that I have been dismissed from my post without giving me an opportunity to hear.
So this is with regard to the introduction.
Introduction.
Main starting point. Now what? Next.
Next, then after serving the notice, the dismissal order under regulation 48. In 48 regulation 2 is there. That authority to which an appeal against an order.
That is, Mr. Goswami, there are two parts there.
Two parts.
One is by the board. One is by the appellate authority.
Appellate authority.
So if it is the appellate authority, then within 30 days it has to do. But if it is the board, subject to what you say, time limit is not there.
No limit. That is I will come to that point. Why? Why 48(1) apply? Why not 48(2) apply? That is another ground.
Okay.
The authority to which an appeal against an order imposing any of the penalties specified in regulation 13(9) lights may, of its own motion or otherwise, call for the records of the case in a disciplinary proceeding
review any order passed in such a case and pass such order as it deemed fit, as if the employee had preferred an appeal against such order. Provided that an order imposing or enhancing a penalty shall not be passed unless the person concerned has been given an opportunity of making any representation which he may wish to make against such enhanced penalty. There is a proviso. Provided further that no action under a sub-regulation shall be initiated more than 6 months after the date of the order to be reviewed. This is the, in case of 48 regulation 2. This is the rule. This is the general rule. Why first rule is applicable to me? That is the thing. Whether after expiry of 1 year, what new causes arises, new ground arises, new offense have been committed by me, then paragraph regulation 48(1) has to be applied for me. Another thing is whether chairman insert chairman have the authority to pass an order of dismissal to me from my service.
That is the point I want you to argue.
Who is the authority?
Come to page 43. Initiation according to this court is not bad. But this order. Come to the 1, 2, 3, 4, 5th paragraph. Page 43, 5th paragraph.
And whereas the court person in exercise of its power vested under regulation 48(1) after calling for the record of the case and reviewing the order passed by the disciplinary authority in its 556 meeting held on 23/1/2013, observed that the penalty of reduction of basic pay by 5 stages in time scale of pay applicable to him imposed on Sri Gogoi by final order dated 20/60/2012 was not commensurate with the gravity of misconduct committed by him.
Okay, now come to the last but one paragraph there. Last but one paragraph, page 43, last but one paragraph.
And whereas on placing his reply by letter dated 25/4/2013 to the so-called notice dated 21/3/2013 before the corporation in its 557 meeting held on 22/6/2030, the corporation resolved that the current insert chairman may take decision and necessary action in the matter. Now, upon considering the said reply,
Fine. Now the thing is done by, thereafter it is done by the chairman. So your case would be that this power could not have been delegated to the chairman. That's your case? Yes. We have no doubt in issuance of that show cause. Fine, no issue. Show cause is fine. 48(1) power you have exercised, no doubt on it. We cannot question that. But 48(1) says it is the board and the board only which can confirm, award, enhance, reduce, or do whatever it wants. How can that power be delegated to the?
Let us come to regulation 4. Regulation 4
Regulation 4
of the staff regulation.
Regulation 4.
My lord has got it. Now, this is the power given as chairman. My lord has got it. The chairman.
Chief executive.
regulation, what regulation?
The chairman, may I read, Lordship? The chairman may from time to time issue such instructions or direction as may be given effect to give effect to, Lordship, very, very important, to carry out the provisions of this regulation and in order to secure effective control over the staff employed in the country.
Now that word has been substituted in 2000 with the word chief executive. We'll say it's the same person. But how will this come in here? He has general power. No problem. Come to 48.
Lordship.
Mr. Goswami, take your seat.
Okay, Lord.
Lordship.
Come to 48.
48.
Read that.
Notwithstanding, may I read, Lordship? Notwithstanding anything contained in this regulation, the corporation may, on its own motion or otherwise, after calling for the records of the case, review any order which is made or is applicable under the regulation, and confirm, modify, or set aside the order. Impose any penalty or set aside, reduce, confirm, or enhance the.
Here, what is to be noticed is that the board, now that word has been changed to board in the
The
year,
corporation,
in the year 2021, that word has been changed to mean a board, some amendment maybe. And the regulation has been made rules.
no, what,
The one which I got, the latest one,
now what I'm having, Lordship, I'm reading from.
it's called the Life Insurance Corporation of India Staff Rules.
It is
notified
a staff regulation, 1960.
Same thing, but some words here and there are changed. You have a copy, Mr.
Staff regulation.
The one that is there with me, it's, I think, the latest one. I think there are some amendments made.
Staff regulation. My lord has got it.
No, I'm just getting it.
My lord will come to regulation 48. As it stands there.
8. Okay,
My lord has got it.
just a moment, You have the act with you?
The act is Life Insurance Corporation of India Act 1956.
Just get it. So, Mr. Nodi, the word corporation here.
Yeah.
We should understand it to be the board of directors. Because section 4, Constitution of the corporation says that it is the board. So wherever this word is used here, corporation, we will understand it to be the board. Am I right?
No, it should be its board, and here, lordship, the power to implement the regulation is given to the.
No. The decision, when it is in 48, it has to be by the board, not by any authority. You read that, notwithstanding anything contained in this regulation.
In the regulation, the corporation may.
One,
Now,
on its own motion or otherwise.
the corporation may of its own motion.
Or otherwise.
Or
After calling
otherwise.
body records of the case.
After calling the records of the case, here
Review.
it's been done.
Review.
Of the case, review any order which is made or is applicable under the regulation. And confirm or modify or set aside the order.
And to be.
And
Impose any penalty
or set aside or reduce, confirm, or enhance the penalty imposed by the order.
Right. Now you come to.
Lordship,
Come to page.
Lordship, for a moment, their reply. Their reply. I'll just take your lordship to the reply for a moment. Page 37. Page 37 of their affidavit petition. My lord will come. That is annexed 10. My lord has got it. Show cause reply against the notice dated. So
He says it will be double jeopardy. That's nothing. That
it is.
cannot be.
It is an admitted fact. Now, lordship, the gravity of the offense committed by them.
I'm not on that. We accept that. But how could the chairman be delegated with the power to consider his? It is the board who should have considered that and passed an order. The power under 48 cannot be further sub-delegated. It has to be by the board.
No, lordship. It is the lordship that my lord will come to this one. Let us take the order again, once again, the impugned order.
Hmm.
It speaks clearly.
You come to page,
Yeah,
you come to page
page,
43.
let us come to page 38 to page 39.
You come to the original at page 43.
No, Lordship, page 39. How is the power
You come to 39, 1, 2, 3, 4th paragraph.
from third paragraph, Lordship?
Hmm.
May I read?
Hmm.
Whereas a show cause notice dated so-and-so was issued, which I have referred to Sri Gogoi provisionally holding him guilty of the charges and provisionally imposing him penalty of dismissal in the service. Whereas on placing reply dated so-and-so to the show cause notice dated so-and-so before the corporation, NS 57, now very important, that is the thing. Held on so in the corporation, it is not, the corporation resolved that the current chairman to take decision.
How can they do that? When the regulation says that it is the body which has to take it.
The corporation by
Cannot justify. Show me how it will be justified.
the corporation by virtue of the resolution.
No. When the power is not there, how can the corporation give it? You yourself admit that 556, it's a provisional. It's a provisional, tentative proposal that we want to impose on this. Now he has given a reply. That reply has to be considered by you, corporation, not by the chairman.
Lordship, whereas upon placing the reply in the show cause, it was
placed. So read further.
before the corporation, it was placed before the show cause notice was placed before the corporation.
corporation.
And in the meeting, it was resolved that the chairman of the corporation
Will take a decision.
To
That
take
means
decision
whether
in
to
that.
impose penalty, enhance penalty, or what to do, it is a decision of the chairman. And the next paragraph onwards, if you read,
upon consideration of the reply.
no,
dated-
that you need not go into it. If you read those
Yeah,
and your affidavit, you have justified saying that the chairman had taken into account each and every factor raised by him.
right.
You cannot. This view of this court, better maybe in the next forum. We are interfering with that.
Lordship,
We are interfering with that order.
Lordship, can I be given 1 week time?
No. Maximum 2 o'clock.
2 weeks.
2 o'clock.
No, I will have to take instructions.
You will not.
Lordship,
Before the next forum, mister.
Tomorrow.
2 o'clock. I can keep it till 2 o'clock. Already invested much time.
Okay, Lordship.
2 o'clock.
Yes.
You find out. If you can show me something justification by 1 week, I'll give you 2 weeks.
Yeah. Okay,
Mr. Nandi can do it. I know. Get
I
it.
will try.
Get it. Because it's education for us also.
Yeah.
And my view is tentative. Till now, tentative. You can change me, no problem. But show me that 48 power can be further delegated. 2 o'clock.
How will I do?
So was it?
57 of the supplementary list.
Mr. Dotto was here.
He was here, but it's a. Taken up sometime, he is
After the motion items.
all right.
For motion item 6,
May please, your lordship. My lord, there are 2 orders of your lordships, my lord. 15, 12, 23 and 13 to 24, where your lordship has indicated that despite there being no restraining order, why the provincialization, my lord, order passed by the director has not culminated into an appointment letter, my lord. Now, in fact, what has happened pursuant to the provincialization order, the director, my lord, having said that I am entitled to provincialization, my lord, the provincialization of my learned friend filing the another writ petition was cancelled. Now,
Where is
he
your
filed-
friend? He's not here.
My lord, my learned friend is there. And in the meantime, my lord, the department has also filed an affidavit saying that my provincialization does not suffer from any infirmity. So I am entitled to, my lord, appointment. That affidavit is at flag A. Now, my lord, the entire, my lord, in fact, the basis, my lord, for not issuing the appointment letter, your lordship will find at para 10. I have stated that, my lord, I filed a
Where is
contempt.
Mr. Islam? Yes.
My lord, I said in my petition
Hmm.
that, my lord, in fact, the contempt application was filed for compliance of the order passed by the honorable court in the earlier proceeding. And pursuant to that, my lord, application, my lord, they, my lord, in fact, passed the order, or they took the necessary steps, my lord,
Hmm.
for hearing the present petitioner and others for
Hmm.
filing, my lord,
Hmm.
for passing the order of the provincialization.
Hmm.
And this is the ground, my lord. I have stated in para 10. What they said me, that you go to the High Court, you obtain an order of appointment, thereafter we will pass the appointment order. Otherwise, there is no impediment, my lord. Here, the director has said, I am entitled to provincialization. Flag A, my lord, is the affidavit. They say, my provincialization.
Yes, Mr. Islam, what do you have to say?
My lord,
You are opposing him or supporting him?
My lord, he is not a party in this, my lord. Lordship will see, my lord, he is not a party in this case. What is, my lord, the fact remains that he belongs, my lord, to language. I belong to social science. Even my post goes, he is not entitled to my post, my lord, in terms of the Provincialization Act. His fight is with
Give me
the other
next
one.
one.
My lord.
Next one.
my lord, kindly see the order dated 16/8/2020, item number 7, my lord. Where the my lord, honorable court, my lord, considered that the matter will examine, my lord, required to be examined. So without examination, your lordship cannot be considered.
Mr. Talda, take your
Madam.
seat. Yes, Mr.
What happened, my lord,
No, 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 this is-
the abolition, my lord, respondent number 10 in my case, my lord.
Huh? Keep that. Hmm? What is your case?
My lord, my case is, my lord, I am a, my lord, appointed, initially appointed assistant teacher in 1993.
Hmm.
In 2002, I was promoted to headmaster.
Hmm.
So from 2002, I am continue in my post as headmaster.
Hmm.
So my lord, as well as I am also teaching, my lord, language teacher, my lord.
Hmm.
And in fact, the
One second.
headmaster teach all subjects.
You admit that you are teaching language
My lord.
and he is teaching social science.
No, my lord, headmaster taught all subject, my lord. As in,
Okay, fine.
My lord.
Accept it. Accept.
My lord.
Show me the material.
My lord, I'm going to that point, my lord. My lord, kindly see, my lord.
I don't want the dice code. I don't want the particulars prepared by you.
My lord.
Any other contemporaneous records, show me. Dice code, according to your inputs, we'll not go into that. With regard to your particulars that is submitted for provincialization, that is also submitted by you.
My lord.
Any other document.
My lord, I am going to that point, my lord.
My lord, if I
The main man has now come.
My lord,
The
if I
main man has now come.
My lord, if I intervene, my lord. if I-
Main man has now come.
My lord. My lord, in fact, on the earlier proceeding, it has been settled. That order is not under challenge.
And
He
Mr.
belongs to
Khan, what
language,
is
my
your
lord.
grievance?
How can he make a contrary
What is your
submission now, my
grievance?
My lord, my service has already been provincialized in terms of the
Language teacher.
lordship.
And according to you, what is Mr. Talukdar teaching?
My lord, he is the social science teacher according to me.
And Mr. Islam?
My lord, he is the headmaster. He, as per their own statement, his own statement in the repetition, he has taken all subjects, including the language subject, that is paragraph 16 of the repetition.
Okay. Mr. Islam, where is their DSC report? DSC recommendation,
Can it annexus 16, my lord?
page 74.
My annexus 16. My lord. First one, page 69, my lord. Page 69, operating part, page 70, my lord. Page 70, my lord.
Your name?
MD Abdul Akhir Ali. In my lord, serial number 6, plus 6, down below, my lord.
Language.
Language.
Abul Hassan, language. And Mr. Khan, your?
Language. Serial number 2, Sapulo.
Okay. So,
Then, my lord, because these are initially unauthenticated because my lord, our sign was not there and the report was returned back. In first 2 pages, page 69, 70, there is no signature, my lord. And only signature is available on page 71.
Sofikul Haq is
So my lord, the matter.
Sofikul Haq. Who is Sofikul Haq?
No, Safiul Haq. I am
Sofikul
Safiul
Haq.
Haq.
You're Sofikul Haq.
Respondent number 9, my lord.
Come to page 74.
Yes, my
You
lord.
are Akhir.
My lord, 74. 74, Abdul Akhir is the, my lord, again Abdul Akhir name is there, my lord.
Language.
Language.
Now,
Here, my lord, the abolition name is not there, my lord. This is the, my lord, signature is there, my lord, the authorities, my lord.
now where did Abul Hussain go then?
Abolition names only in the, my lord, page 70. In the first report, my lord.
Okay. Okay.
The first report was remanded back, then examined, then, my lord, page 74 was, my lord, considered, my lord.
Hmm.
And another, my lord, page 75.
Hmm.
The school has, my lord, the enrollment more than 100, my lord. So one headmaster is, my lord,
Forget it.
my lord,
You file a case for that.
my lord. Then, my lord, kindly see the, my lord, the page, my lord, page,
You
my
come
lord, page 93.
You are Abdul Akhir Ali.
Yes, your lordship.
Okay.
My lord, kindly see page 93. The
You
impugn
come
order.
to page 122.
My lord,
22.
120. Page 120. Yes.
Hmm?
120.
Abul Hassan.
This is his own document.
Where is Abul Hassan here? In page 122.
My lord, as
Abolition
my
is
name
not there
was
because
not
what-
there, as my name was not
My
there,
lord.
2 English teachers were provincialized.
No.
I
In
came
the
before you.
particulars that is submitted by the principal, by the headmaster,
Yes.
My
page
lord,
122, why your name is not there?
because my lord, he was discharged from the school and thereafter he never back, my lord. I'm going to that point, my lord. In 2013,
So
my
who
lord,
have been now provincialized?
My lord, by the provincialization, my lord, the petitioner Abul Hassan and my
Abdul
lord, the
Hassan.
client of Mr. Khan, my lord.
Huh?
Mr. Client of Mr. Khan and the Abul Hassan, my
Then
client.
give me the names.
Abul Hassan, my lord, and my lord,
Safiul Haq
Sofiul Haq.
and one science teacher, Idris Ali.
Science teacher. Jurisdictional.
My lord. My lord, why abolition, Safiul Haq name intact, my lord? Because he was initially appointed in 1993 as headmaster. In 97, he was resigned from the school, my lord. Again, he
So
was
you
repaid-
joined the school on 12/3/2002.
my lord, as a headmaster, not my lord, assistant teacher, my lord. Assistant teacher, he was appointed in 1993.
Where?
My lord, kindly see page, my lord, page, my lord, 95. Resolution,
Okay, where is the form submitted by you?
my lord.
That forms are submitted?
Yes,
Yes,
your lord.
madam. You have the
Yes.
records? Give me the records.
My lord, kindly see,
We'll settle it. The
my
forms
lord,
will
kindly see
settle it.
page 68. Page 68.
Just take out the forms for me. Individual application forms.
My lord, kindly see page, my lord, 68 of my writ petition, my lord.
This is nice data.
Yes, your lordship.
Last thing we will look into.
My lord, teacher's report, my lord, submitted, my lord.
Last thing we will look into when the headmaster is involved. Last thing this court will look into.
My lord. No, my lord, at this time, my lord, his money in the hair, his appointment mentioned in 1993.
He's preparing documents as per his convenience, being the headmaster, my lord.
Where is that form, madam?
The last page, like.
Mhm.
My lord, regarding my lord, page number 69, my lord, this is the
No,
original.
no, no. I want the form submitted by each of the parties before for provincialization. They fill up a form, particulars form. Where is that? It's not here. They fill up a form,
My lord.
madam, that this is my post, this is my date of joining, sign it, and then the principal headmaster forwards it to the district scrutiny committee. I want that form.
Well, perhaps it is not in the.
It's not here.
record. Well, if your lordship go by the page number 93, my lord.
Okay, what we do is, Mr. Talukdar,
My lord, can I
Mr.
have one
Islam.
line, my lord?
No, Both of
One
you.
line, my lord.
Fine, I got it. Give me some material.
Yes.
We'll have it after the list is over. We'll finish it today.
Fine.
Just give me a small table when you were appointed, your consideration, and the decision by the government pages.
Right.
One page. You also give me a page.
My lord, in my reply, I have given a table, my lord, of every
Yes,
yes, paragraph.
What
3,
we
my
do is, we'll just finish up the admission items
My lord,
and then we'll call for this.
paragraph 3, my lord.
And madam, if you see in the records, somewhere that form is there.
My lord, will only take note of one aspect of the matter. The earlier proceeding, my lord, is not under challenge. There,
You got
my
it.
lord, this honorable court has held, he belongs to language. Now, can he develop new story without challenging that order, my lord?
Earlier, no opinion was passed by the honorable court. Honorable court demanded back the matter.
Mr. Islam, can you change,
Yes,
keep on
madam.
changing that I am this, I am that, I am that.
Approbation and
Can you-
distribution, my lord.
No,
The
my lord.
particulars which you file, you say you are a language
The
teacher.
liberty
You
was
will have
done.
to, you can't change status. Have you brought any material on record to show that, see, this will show that I am taking social studies classes? Anything
No, my lord, no
other
one
than
can
your
show.
dice code and
Appointment was not made subject wise, my lord.
fine, no need. But you yourself have projected yourself in the particulars. 122 saying that I am a language teacher. Why? Why? How do you come out of that?
No one can show, my lord. No, even
We not.
even other.
We believe you. We only believe you. As far as your particulars are concerned, we will believe you.
Fine.
You have declared.
My lord.
Anyway, come back after the
Obliged.
admission items. Admission होने के बाद बुलाना.
Item
And you,
8,
Mr. Talda, just give me a small.
My lord, I'll-
item 8. 8,
Issue notice. None appears for the petitioner. Issue notice. Returnable 4 weeks. Petitioner to take steps by raised a post with, take steps for it, take steps for service of notice upon the sole respondent. But upon the respondents by way of raised a post with AD, steps within 3 working days.
item 9,
Maybe later, Lordship.
Your name? Name?
Arrive here, my lord.
Issue notice. Sole respondent. बाकी एक नाम तो ले लो बता ले. Sole respondent. 4 weeks.
10 and 11,
Yeah, please, Lordship, the last occasions, your Lordship directed the state government, to take instruction. Why the appointment of the headmaster?
Forget it. We will go by the other thing. There was a query made to you.
Yes, madam.
Satisfy that first.
That query is there, that where show me that rule is there, regarding rules.
And you are appearing for both Ram Nirod Singh as well as the.
Yes, because
institute.
because there no conflict of interest.
There can be. Tomorrow, if we hold that Ram Nirod Singh is not entitled, then automatic, there would be a conflict. That's what the court indicated in the order.
Yeah, I don't
You
think,
satisfy us on the first person first. If you're not prepared, take some time. We'll
no,
allow you.
regarding what, my lord?
With the order 19/2/2024. Read that order. There
Ah,
is some discourse.
I 19 to 23 order.
You read it, Mr. Mitra. Tell us when you are ready. Call after something.
item 12,
You go through it.
May it please, your lordship. My lord, before I proceed, my lord, these are matters, my lord, petitioners on similar footings in which your lordship has on, my lord, couple of weeks back have intervened and have protected us regarding, my lord, the 18 months diploma. My lord, these petitioners have acquired, and we are challenging the notification by way of which, my lord, we have been disentitled from participating in a recruitment process wherein, my lord, this 18 months diploma has been, my lord, rendered invalid by the interim notification, my lord. And your lordship, in the previous few, my lord, petitions that have been filed by similarly placed my lord, candidates, my lord, your lordship has issued notice and has protected them that these are the candidates who have submitted their online applications before the last date, that is 12th of February, and has been accepted by the department and have acknowledged that in their emails, my lord. So they are also on similar footings, my lord. So today, I'm just praying, my lord, your lordship may kindly, my lord, the order of your lordship is at page 410, my lord.
Similar order.
My lord, we are praying for similar protection, my lord.
Heard Mr. H. Buragwani, Learned Counsel for the Petitioner, also heard Mr. D. Kaushik, Learned Standing Counsel for the Department of School Education, Assam, and Mr. A. Alam. You are paying for?
I alone for NCT, my
Huh?
NCT, my lord.
Respondent?
Four, my lord.
Page 17. my lord.
7.
Mr. A. Alam, respondent appearing for the Standing Counsel, NCTE. Also. Mr. B. Kaushik, Learned Standing Counsel, Elementary Education Department, accepts notice on behalf of the respondent number 1 and 2.
1 and 2.
The so and so, Mr. Give it to Mr. Arkady.
I'll inform, my lord.
Mr. Arkady Chaudhary, Learned PYSGI, accepts notice on behalf of respondent number 3. Mr. A. Alam, you both for 4 and 5? 4.
5 notice needs to be.
Respondent number, Mr. A. Alam, Standing Counsel, NCTE, accepts notice on behalf of respondent number 4. No formal notice is issued. However, requisite extra copies will be furnished to the Learned Counsel. Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD. Also. The petitioners in the present proceedings are all holders of 18-month diploma in elementary education. Also, it is contended by the petitioners that in pursuance to the advertisements both dated 26/12/2023, the petitioners had uploaded their respective application against the post so advertised before the last date so fixed for the same. That is before
12th of February 2024, my lord.
12/2/2023. Full stop. Kishore, A8. Page 410 of the. What 400.
Your lordship has given us a liberty to undertake an exercise, my lord, wherein we should be providing them with the registered, my lord, numbers against the application. We have again served them with all.
That you do with.
Yes, my lord. I'm deeply obliged, my lord.
13.
My 13, my lord, similar, my lord.
Similar. Parties are same.
My lord, similarly situated parties, my lord. They are also, my lord, have filed their applications, my lord. On
Before 12.
before 12, my lord. As a matter of proof, my lord, they have submitted.
No, it's okay. Mr. Buragwani is saying that is enough for us. Mr. B. Kaushik, Learned Standing Counsel, School, Secondary School, Department of School Education 1 and 2. DY. Okay, huh? For respondent number 3, 4, Mr. Alam, 5, Mr. 5, registered post. Double. I got to do the same. Or order to same thing.
I'm highly obliged.
Yeah, to it to me, not a copy.
I'm highly obliged, my lord.
14.
Lordship, I'm extremely sorry, my lord. I was in another good item number 8. I missed lordship.
Yeah, we should notice. Mr. G, you are
G.
Mr. D. Gugui.
G Somual.
G Somual.
G Somual, lordship.
8 of liquidity.
Extremely sorry, my lord.
No, we should notice.
Oblige, my lord. Oblige.
Her non-appears liquidation, G Somual liquidity, council body pension. You take steps within 3 days.
14.
May I please, your lordship? Matter may be taken up after some time. My senior is. Obliged.
15.
May I please, your lordship?
Yes.
Your lordship, in this matter, your lordship, what has happened, your lordship, that I was suspended, your lordship.
on your lordship 0404/2022, Annexure 5.
Hmm.
Thereupon, your lordship, I had challenged the suspension order
Hmm.
and the Honorable High Court by order dated 12/8/2022 had set aside the suspension order and directed the
Yes,
respondent
yes.
to reinstate. Now, my,
One thing, tell me,
yes, your lordship.
has a proceeding been initiated against you?
Yes, there
When?
was, there was this proceeding initiated against me.
When?
If your lordship peruses para 10, page 13, your lordship, show cause notice was issued on 24/06/2022. And I had submitted my reply, your lordship.
Para?
Para 10, your lordship, I have made a statement to that effect, your lordship, page 13.
So there is a, show me your suspension order.
Yes, your lordship. Your lordship may very well peruse page number 36, your lordship, Annexure 5.
So after 4/4,
Yes, your lordship.
a notice, show cause notice under rule 9
Yes, your lordship.
was issued on 24/6
Yes, your lordship.
and that is pending.
Yes, your lordship. Departmental proceeding is still pending, your lordship.
Then this period cannot be regularized, Mr. Until and unless that is not cleared.
Yes, your lordship. I'm relying on you because the Honorable High Court had set aside the suspension
And
order.
said that you do it within 4 months.
Yes, with a
But it
direct,
does not say that if it is not done within 4 months, it will stand, it will lose its significance. That wording is not there.
yes, your lordship. My only humble submission that the departmental proceeding be concluded within a time frame.
That can be done.
But the period of suspension wherein my period of regularization during that suspension period, in accordance to rule FR
54B
54B,
says after conclusion.
your lordship, may I just have a look at your lordship?
Please.
Your lordship, I'm also relying on a judgment of the Honorable Apex Court, your lordship. But I don't have the, your lordship, the extra copy, but AI
But tell me,
1962
what is it? Citation.
Yes, your lordship. AI 1962. ST 1334.
1962.
1334, your lordship.
Name?
Your lordship, the name of the case, your lordship, is your lordship. Devendra Pratap Narayan Rai Sharma versus State of Uttar Pradesh and others, your lordship.
What is the proposition?
The proposition, before I state the very proposition, your lordship, what has happened in that particular case
FRSR local too.
was that, your lordship, the petitioner was suspended. Thereupon, your lordship, he was dismissed from service. Then he challenged the dismissal order before the civil judge, which was also the suit was dismissed. And thereafter, he had approached the Honorable High Court. The Honorable High Court, stating that there was no afford of any reasonable opportunity, had set aside the dismissal order. Thereafter, he was again reinstated. And after that, your lordship, again, your lordship, second inquiry was concluded, was initiated against the petitioner. Then, your lordship, again, he had challenged the same on that second inquiry could not be initiated, and on the ground that the period of suspension wherein he had prayed for direction that his pay and allowances during the period of suspension be given to him was also, your lordship, considered by the Honorable High Court. Your lordship, during that time, your lordship, it was confirmed by the High Court that his pay during the period of suspension be given to him. Thereafter, but he had challenged, but his second inquiry, where departmental proceeding was initiated, was not considered. On that particular ground, he had approached the Honorable Supreme Court, and thereafter the Honorable Supreme Court has stated that, yes, to that effect, the High Court was correct in observing that his pay and allowances during the period of suspension be given to him.
Period of suspension under the first proceedings.
Under the first proceedings, your lordship.
That proposition is fine. But in your case, that will not apply because your first proceeding is still pending.
Yes,
If you
Your
come
Lordship.
to 50, 58,
Yes, Your Lordship.
apart. 54, sorry. (54)(b).
Yes, Your Lordship.
When a government servant so-and-so is reinstated or would have been reinstated but for his retirement on superannuation, while under suspension, the authority competent to order reinstatement shall consider and make a specific order. 1, 2, 2
Yes, sir.
dies. Then this thing,
Your Lordship, Rule 5 also, sub-rule 5.
come to 6.
Yes, Your Lordship.
Where suspension is revoked pending finalization of the disciplinary court proceeding, any order passed under so before conclusion of so-and-so shall be reviewed on its own motion after conclusion of the proceedings by the authority mentioned in so-and-so, 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 so-and-so.
Your Lordship, I pray that Your Lordship, sub-rule 5 also may be considered. Your
In the cases though following so-and-so, so-and-so, the proportion so-and-so, 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 so-and-so. Okay. What we say we do is, we'll ask them to conclude the proceedings within a particular time period. 4 months? 4 months.
4 months.
And if you don't do, he will be given all the benefits.
Yes, Your Lordship.
Where is your show cause?
Your Lordship, I have not annexed, Your Lordship.
What is the charge against you?
The charge against me is that, Your Lordship, I have committed, Your Lordship, violation against the Right to Education Act, malpractices, Your Lordship. If Your Lordship peruse page number 36, Your Lordship, suspension order.
No, that is there. That is just vague.
Yes, Your
But
Lordship.
exactly that is the charge against you. What is the allegation?
Allegation negligence of duty failure.
No. In the show cause. In the show cause,
Your Lordship, I have not annexed the show cause.
you have a copy with you.
No, Your Lordship, unfortunately, I don't have, Your Lordship.
Can you give me a copy by Friday?
Your Lordship, I have to seek instruction. I will provide Your Lordship. Just give me a
Friday.
week's time.
Friday.
Yes, by a
Friday.
week's time, Your Lordship.
Huh?
A week's time.
We'll have it on then 27th.
Yes, Your Lordship.
List this matter again on 27 to 2022. The petition shall bring on record, shall furnish a copy of the show cause notice issued to him on 24/6/2022. Just give me a copy.
Yes, Your Lordship.
Interesting point.
Much obliged, Your Lordship.
Well, keep this up.
Much obliged.
16,
Late precedents, matter relating to removal of president of SMC minutes. The petitioner was approved as the president and respondent number 5 was approved as the vice president of the SMC. On complaint filed by the another member and hearing was conducted.
Yes,
in the-
Mr. Kaushik, what is this?
As per
Page
Rule
35.
35,
Huh?
Page 35 gives the
Ah,
order.
ah.
that
Proceed.
cannot,
All the members have
8 members.
8 members. It's as like as the no confidence
Hmm.
minute.
And is provided for.
It's provided for it.
Now, if you can come to the rules,
My lord.
13, page 255.
My lord.
You have the rules with him?
Yes, my lord. On similar situated cases, your lordship suspended the improved order.
I made a mistake maybe.
My lord.
I made a mistake. maybe.
My lord. On appraisal.
Just one thing, Mr. Kaushik.
My lord.
13.1 is the procedure, right?
For removal also.
No. 13.1, page
My lord.
255.
My lord.
How you appoint, right? Now, if you come to 35,
Removal.
no, first you read 5.2.
Yes.
A person shall not be qualified to be president, vice president, members who can be removed by SMC through a resolution not at least 2/3 members present, which should not be less than equal to 50. Now, that is satisfied here. Or by the district elementary education in this count shall come into effect from the date the approval of the resolution in this regard by the district education officer concerned. Now you come back to 1.
My lord.
If 5.1, if any vacancy is caused due to so and so, the same shall be filled in accordance with the procedure laid down in this rule for election of so and so. So he is a member first, then he becomes the president. He is removed. Now, is it not required to have that vacancy also filled up thereafter, nominate, or it can be done
So, 13.5 deals with, my lord,
removal?
removal from the precedence.
That's why I said if any vacancy is caused due to resignation, removal, or death of the president
President and vice president.
or member,
Or a member.
the same shall be filled up in accordance with the procedure laid down in these rules for election of president, vice president, and members.
And members.
So you'll come back to 13.1 again.
13.1 again. And this, my lord, this here, he has been removed as a president.
He has been removed.
He's removed.
And is brought back as a vice president.
Yes.
And that has been approved.
That has been approved. And he has not removed, as on today, he has not been removed from the member.
He's not removed. He's just brought back.
Yes.
He continues as a member.
He continues as a
Yes,
member.
continuous member, but
Issue notice. Heard Mr. R. Islam Learned Counsel for the petitioner. Also heard Mr. P. Kaushik Learned Standing Counsel Elementary Education Department for
1 to 4, my lord.
1 to 4. Also, Mr. Kaushik Learned Counsel for the Elementary Education Department. Issue notice, litigation, 4 weeks. Issue notice, returnable 4 weeks. Mr. Kaushik Learned Standing Counsel accepts notice on behalf of respondent number 1, 2, 3, and 4. Heard Mr. Swaranson, heard Mr. B. Kaushik Learned Standing Counsel, Elementary Education. Baki guli. Accepts notice on no formal notice is issued. However, extra requisite copies of the petition, requisite extra copies of the petition be furnished to the Learned Standing Counsel. Petitioner to take steps for service of notice upon respondent number 5 by way of registered post with AD. Want to do it, Dusty?
yes, my lord.
And also by way of Dusty mode routed through the registry of the school. Also, issue notice on the prayer for relief, interim relief. Also returnable on 4 weeks, Dishuna. Issue notice returnable on 4 weeks only, 19/4 ko idea. 19/4, also returnable on 19/4. Also, the approval as granted to the removal of the petitioner as president of the SMC of the school in question shall be subject to further orders that would be passed on 19/4/2020. 19/4.
Obliged.
17,
Is this the correct forum? I think you have to go before the division bench. The Learned Counsel for the petition submits that in the present proceedings, the provisions of the rules, that is the Assam Secondary Education bracketed provincialized schools bracket over service rules 2018 is under challenge. More particularly, schedule 3 thereof. So accordingly, the registry to examine as to whether the registry to examine the matter, and accordingly, the matter is to be considered by the division bench. Also, registry to consider the matter and place before the appropriate bench.
Lordship, can a date be fixed?
I can't.
18,
Obliged.
None appears for the petitioner on call.
Lordship, can the matter be taken up after some time as Mr. Khan?
After some.
20,
Lordship, senior is on let's
After some.
after some time.
No, we continue.
My lord, that item, actually what my knowledge goes, my lord, there's a good, my lord, but actually this is practice going on, my lord, there, since if you go to 77, my lord, then the.
No, Mr. Mitra, my problem is this court has said that you will have to give the provisions. File a review, otherwise you give me the provisions. How can I go beyond that?
No, because this is a procedure, because there's Supreme, as per Supreme guidelines, I have annexed all those later, my lord, what is written by the joint eligibility education joint secretaries written secondary school that.
We'll do one thing. You're here?
Yes.
You're here today?
Yes.
After the admission matters, we'll take it. After the admission matters, we'll take it.
Or if you're lordship, but I can take it next week also.
Okay, fine. On the prayer of Mr. S. Mitra, item number 11 and 10 and 11. Please this matter again on 1/4/2024. 1/4/2024.
Can you have third, my lord? Third.
Third कर दीजिए, third. Mr. Dr. is here, yes. Call.
1957,
Yes, Mr. Dr. You have got the record.
Yes, yes.
What is the material?
Material is there, ma'am.
This is item number.
Hello, your lordship may look at page 3 of the disciplinary proceeding. The entire thing will be clear from there. Proceeding dated 5/7/2012.
Mr. Dr. We know this. No doubt on this. But how did you exonerate the cashier?
Yes,
That is what we wanted from you.
that, my lord, I will take your lordships to the exhibits. It
Hmm.
will be very clear from there.
Hmm.
All works are handiworks of the, my lord, the managers. My lord, there, the exhibits will make it clear.
Where?
The lordship may look at ME8, my lord.
ME8.
The modus operandi your lordship will find, he created some loan account in favor of one Mr. Narachandra Bashumatari. He was the customer of the bank.
No doubt on that.
ME8, your lordship can see.
ME3. ME6.
SB account number 4 in the left hand side.
ME7. ME8, yes.
This is his Nara in the left hand side, your lordship will find.
I'm least bothered with this, Mr. We are convinced.
Yes,
What I want is,
my lord.
these are all things which have come in after the show cause notice was issued. Why did you not issue a show cause notice to the cashier?
Now, your lordship.
That should be a decision prior to this. Where is that decision? That's what we want from you.
Your lordship may see then ME 16. This is
ME
the
16.
statement of, my lord, the manager.
Manager means the petitioner.
Yes, my lord. He is Mr. Rabindranath Sharma. Now, this statement, your lordship kindly see 10/1/2009. Uposthit Asilu. The lordship got ME 16. The date is 10/1/2009.
Serial number 16.
Ingreji tarike
No,
uposthit
brancher,
Asilu.
sabi, manager, hatat thake. Okay.
Now, I will take your lordship.
Control sabi, manager, hatat, aru manager, sutit thakile, in
No,
charge hatat.
before that, your lordship kindly see. He wanted to say 9:10 ahisu. That means he came in the office 9:10.
Where are you
In
reading?
the top, your lordship will find. Date is mentioned 10/1/2009.
Tarikhe
Then-
upasthit asilu.
Aru Sarita Bojat.
Sanota bozat ahishu.
No, before that,
Saita bozat goishu.
he came in the office at 9:10 and left at about 4 o'clock. Then so far Kandarpa Kumar Kalita, advance officer, he came on 9:40 and left at 2:30. My lord, the timing is very important and that's the reason I'm showing, my lord. Madhuram Boro, cashier, came on 9:30 and he left at 3. Too much of noise. Then, my lord, Dharmeshwar Ramchiari, he came at 9:20, then left at 3. Then your lordship kindly see 14. Branch sabi manager or hatot thake.
Fronto sabi manager hatat aru manager sutit thakile.
Then, my
in charge
lord,
of hatat thake.
front or sabi, these are very important things. Front or sabi manager or
That is,
hatot.
now come to 16.
Then your lordship.
Strong room or dorza to collapsible gate sabi cashier or hatat ase.
Harmony dinner porai.
Ah.
Now this is his statement.
Ah.
Then Volt or sabi DM aru cashier or hatot thake.
Ah.
Now your lordship kindly see if the front door and
No,
the
Mr. Doctor, we are not sick. These are all something which has come in after that. Why did you first, at the first instance, only proceed against him and not against the cashier?
I'm convinced, your lordship. Well,
No, I want the material.
then last question, your lordship kindly see.
Or we will interfere with this because both are alleged. You can't have against one man.
No, question 20, your lordship. Who is the person who did it? My lord, from his answer, it will come up.
Mr. Doctor, that will come in once you have proceeded against him. What made you decide to proceed against him?
My lord, the reason is, that's the reason I'm trying to persuade your lordship.
These are subsequent. These are not reasons.
This
When
is-
you issued the show cause to him.
No, my lord, why I'm saying, the manager himself is making this very, very specific statement.
We are not with him. I'm only on the quantum. This issues quantum. If there was somebody else who was equally responsible, you have allowed him to go because his case from day one is that, see, this is with him. He requested, so I did it. I did a mistake,
My lord,
but I did it.
yes.
And he is guilty, banker, no leniency will come to him.
No, here, my lord, so far cashier is concerned, from the materials and record, I will persuade your lordship that cashier was not in picture. It is, even the second and third charges make is very clear. My lord, I'll read again.
We understand, but everything flows from that loss of money. Loss of money, here also he says that this is with the cashier. Now, was cashier examined in the inquiry?
Now, what he has said.
No,
that
was the cashier also brought in the inquiry?
Yes.
Where is this?
His statement is there. My
Where?
lord, I'll read question 20, your lordship can see. Abeli cash rakhar homoy officer ভিতৰত আনুমানিক 241 2 lakh 41,000 হব. That
2
means
lakhs
on that particular, he is referring 10/1/2009. He is saying that on that particular date, this much amount was there. And 10 happens to be Saturday. 11 is Sunday. 12, when the cashier came, he went there, he found that trunk is missing.
Okay, now just
Now-
come to the
Now,
statement of,
why I'm saying so? Because the manager said on that day, he went last, fourth. All other officers and staffs, they have left.
we
before
got it,
that.
we got it.
Now, he has seen that exact amount was in the strong room and he closed that.
Very good.
Then,
Now just show me the statement of
Yes,
the
statement of-
cashier.
that is, my lord, the lordship may turn to page ME 14, my lord.
Cashier.
Cashier, he is the
Hmm.
cashier. Moor naam Madhuram Bora. Then question 4, your lordship see. 10/1/2009, মই মোৰ কাৰ্যালয়ত উপস্থিত আছিলো। সেই তাৰিখত মই মাননীয় কন্দৰ্প কুমাৰ কলিতা, হিজ অফিচাৰ এডভান্স,
For a cash hisab.
পৰা কেছ হিচাপ কৰি বুজি লওঁ। কেছ বুজি লওঁতে চেইফৰ ভিতৰত 30,85,149 আৰু চেইফৰ বাহিৰত ষ্টিল ট্ৰাংকত 20 lakhs পাওঁ।
Hmm.
Then question 5, 10/1/2009 তাৰিখে লেনদেন শেষ কৰি হিচাপ মিলাৰ পাছত চেইফৰ ভিতৰত 45,50,000 আৰু চেইফৰ ভিতৰত 2,41,000, exactly that amount, 2,41,533 ষ্টিল ট্ৰাংকত থোৱা হৈছিল। Then strong room বন্ধ কৰাৰ সময়ত মোৰ লগত ঋণ বিষয়া শ্ৰীযুক্ত কন্দৰ্প কুমাৰ কলিতা আছিল।
Hmm.
ষ্ট্ৰং ৰুম বন্ধ কৰাৰ আগতে মই চেইফ, ষ্টিল ট্ৰাংক তোলা আৰু ষ্ট্ৰং ৰুমৰ গ্ৰিল আৰু দৰ্জাৰ তোলা বন্ধ কৰিছিলো। Then number 8, 2,41,533 ষ্টিল ট্ৰাংকত হৈ 12/1/2009 ইংৰাজী তাৰিখে দৰ্জা আৰু গ্ৰিলৰ তলা খোলাৰ পিছত দেখা নোপোৱাত মাননীয় শাখা প্ৰবন্ধ শ্ৰী ৰবীন্দ্ৰনাথ শৰ্মা আৰু শ্ৰীযুক্ত কন্দৰ্প কুমাৰ কলিতা মহাশয় মাতি আনি অৱগত কৰিছিল।
Hmm.
Now, this is the categorical statement by him.
Hmm.
Now, this is
No,
all-
he does not say that the key was with the branch manager, because if your stand is that requires two keys to open.
Well, key is obvious, my lord. So far strong room is concerned, the key will be one with the cashier, one with the manager.
Then,
And both the person will have to open it.
Open
One
it.
key will not open.
so both, how can they, because he says, I locked it and I moved out and there was 2 lakhs. Now, if that amount was there, after 10th, the key is with him, one key is with him, one is with him.
Yes.
Both not coming together, how can that be opened?
Now, manager himself said, I have closed the strong room on 10/1 and he found
No,
2,41,000.
he says, you're this friend, you're this cashier, 10/1. Safer ভিতৰত মই strong room বন্ধ কৰা আগতে মই safe steel trunk ভালদৰে strong roomৰ grill আৰু দৰ্জা তলা ভালদৰে বন্ধ কৰিছিলো।
Huh.
So 10/1, both of them locked.
Yes.
Then on 12, if the money is missing, how can one be responsible? Both have to be
No,
responsible.
your lord, that's the reason, my lord, I am again and again saying,
Hmm.
if your lordship look at the statement of the manager,
Hmm.
he has candidly said
Hmm.
that on 10/1, amount of rupees, this disputed amount 2,41,000.
You come to 16 now. We have seen the
16,
statement of,
yes.
come to 16.
Yes.
Strong roomৰ দৰ্জা collapsible gateৰ চাবি কেচিয়াৰৰ হাতত আছে। So if the cashier had locked and gone and the strong room key requires 2 because the steel box is inside the strong room.
Yes.
To enter if it requires 2 keys.
Yes.
Now, without the key of the cashier and an explanation how that key has come to his possession, how could have he only been proceeded against?
Now then the statement of the manager,
Hmm.
it has got some meaning, my lord.
Hmm.
আবেলি কেছ ৰখাৰ সময়ত বাকচৰ ভিতৰত অনুমানিক 2,41,000.
Right, and this you say, this is supported by your cashier.
Cashier.
He says 2,41,000 and you come to back to page ME 14.
ME 14.
Hmm.
Yes. ME 14 I have said, my lord.
Clause number 5.
2,41,533.
2009 তাৰিখ ইংৰাজী তাৰিখে লেনদেন শেষ কৰি হিচাপ মিলাৰ পাছত চেফৰ ভিতৰত
45 lakh.
ছশ চেফৰ ভিতৰত থকা নকদ 2,41,400 টকা ষ্টিল ট্ৰাংকত পোৱা হৈছিল। So he has kept that amount.
Yes,
So the branch manager will know how much the cash is.
right.
Now, if the branch cashier has logged it,
No, both of them.
both of them, then why against one? Why not against control proposition?
The question is from the record, your lordship will find
Mr.
the exhibit.
Mr. Dutta, this is not the answer we require
No,
from you.
my lord, then your lordship can.
You can come to the question which the query this court was put.
Yes. If I exactly
15 to
understand the query,
2024.
if your lordship,
Mr. Datta Sono Learned Senior Counsel praised that he be granted 2 weeks' time to produce the records pertaining to the inquiry contending his will and under challenge in the present proceeding. That is one. As well as the verification done by the bank pertaining to the role of the cashier in the incident now alleged against the petitioner, more particularly with the regard to loss of cash from the stone. Where is that material?
my lord, if your lordship look at exhibit 9, how it has been made, your lordship kindly see. It is the handiwork of the manager. Lordship kindly see.
Mr. Doctor, we have no doubt in our mind. But we want to know the genesis, how this thing was moved by your bank.
Your lordship want to say how the cashier has
Was
been made scot-free.
you did not proceed against him? Why? That's the answer I want. And that too now after this statement.
My lord, the exhibits, if your lordship look at,
Exhibits, Mr. Doctor comes subsequently. Charge number 2 onwards, he is guilty.
yes.
But we want to know.
My lord,
how?
can I read the charges once again? My lord, I want to clarify myself. My lord. It is page 21, my lord.
Charge number 1 is information.
Yeah, one is, my lord, an incident of missing of cash amounting to so and so from strong room had occurred in your branch on 12/1/2009. The amount was logged in a remittance trunk. Your lordship, can you see? They cannot keep any amount in the remittance trunk because this is illegal and against the norms of the bank, because it will have to be kept in the vault. And if there is any excess amount, you will have to send it to the designated office, my lord.
So we'll conclude that with regard to that second part, the bank has got nothing to say.
Now, the second part is, your lordship,
That charge number 2 onwards, we are convinced. We
2
don't.
and 3 is more dangerous.
I know that. I know.
Now. this
But I
is
just want to know the thought process of the bank when they started a proceeding against you. Why?
my lord, let me share your lordship's query to the person, if anybody is there who conducted the inquiry, if he's there.
No, the records will have to speak. Because once such an allegation comes,
My lord,
and the key, you also say, key should be with them. Somewhere you say both the keys are with it, which is now in the inquiry, it's not proved that no, keys are individually kept. Now, why did you leave it?
I can understand, my lord.
Only that much.
My lord, let me do one thing. Let me
Only with
share-
regard to the quantum, not with regard to the
No, that I
conviction.
understand, because otherwise, my lord, it
He's-
will be. that is
What he
the
did
premium
as a
to the-
banker, he does not deserve any mercy.
Yes.
But the quantum. If we find that there was a deliberate attempt from the bank to shield someone and to project him as the only villain, then maybe we'll have to.
My individual perception, but my lord, after going through all these, it appeared no such things happened, just to shield one person.
Because
And-
my view is with regard to that statement of the cashier, because he logged, there is no material after that. That how could he on his own open and take? If there was something on that time, no doubt about it. That is missing. That key area is missing.
Your lordship is very correct. Only thing in the banking proceeding, your lordship will find, the witnesses come and the way they are to say many things to clarify the entire thing is not like other, they're not expert in that way. So therefore, they just give a hint to it And my lord, they think that as if we have to get everything from there. So that's the, my lord,
That's-
almost all the proceedings I have found that.
Can we retain this,
Yes, yes,
Ma-
my lord. Only
Mr. S.
thing-
Doctor, Learned Counsel, representing the,
One thing, my
Fine.
lord, can I say one thing? My lord, if I want to share with the officer concerned, my lord, I think I'll have to take this also.
okay, fine.
Because they will have
Alright.
to explain it from there.
Okay. No, like Mr. S. Doctor, Learned Counsel, Senior Counsel, appearing for the respondent bank has placed before this court the proceedings, records of the proceeding conducted against the petitioner. This same is returned here. Mr. Doctor on the next day shall receive categorical instructions from the bank authorities as to why the bank had decided not to proceed against the cashier for the loss of the amount from the strong room. More particularly, considering the statement of the cashier made in the inquiry proceedings held against the petitioner hearing. List this matter again on 27, 28. 28 will do,
My lord, can it be after that, my lord?
then
If
let
it
it
is
be on
on-
second.
Second, yes.
Two, four. Mr. Doctor, for a minute, don't worry, we are not with him,
No, no,
but
that-
we want to
no,
know,
I understand the query of your lordship.
we just want to know.
I want to be satisfied myself. also.
Can it be on first and my lord? No,
Second.
second. But
Fourth,
No, fourth, my lord, I have a partner matter in the. division.
whenever both of you date any convenient date, just
Nine.
inform her.
eighth,
Mr. Roy,
let it go on eighth, my lord.
just inform her.
Eighth April. huh?
Eighth.
Just 1 minute.
Your juniors can inform her. She'll fix that.
All right, my lord.
Next. Hold on. 18 and 20. 18 and 20.
Timing 18.
Perhaps at this stage, Lordship would like to issue a notice on it.
Near regularization.
Yes. Three options.
Three options. Heard Mr. K. N. Chaudhary, Learned Counsel for the petitioner. Assisted by your S.
Yes, Ahmed.
S. Ahmed.
Sabina.
Sabina Ahmed. Assisted by Ms. S. Ahmed, Learned Counsel for the petitioners. Also heard Mr. S. Das, Learned Standing Counsel, Higher Education Department. Issue notice, returnable 4 weeks. Mr. S. Das accepts notice on behalf of the respondent number 1 and 2. Mr. B. Gugui, Learned Standing Counsel Finance, accepts notice on behalf of respondent number 3. No formal notice is to be issued. However, requisite extra copies of the same is served upon the Learned Counsel for the respondents. So on the returnable date, the Learned Standing Counsel, Higher Education Department shall receive this instruction with regard to the grievance expressed by the petitioners in the present proceedings.
In fact, my lord, the major chunk has been given that fixed pay.
Fixed pay.
That
But
55,000.
I don't understand one thing, they went ahead and they withdrew that.
Yes. So when there and we,
Withdrew.
anyway, come on.
That's
20.
I'm sorry, my lord, I was.
no, it's okay. It's okay.
My lord, the Assam Don Bosco University is before your lordship, assailing my lord to notifications. In effect, my lord, by these notifications, the university has to get its affiliation to Shankardev University.
Which is
And
not
they will hold
possible.
the selection for admission. They will also hold the exit test, exit examination. Although, my lord, the Pharmacy Council of India is holding the examination. My lord,
One thing,
today-
Mr. Chaudhary, just in
My
the
lord.
meantime, I'm interpreting.
Today, I am not bothering your lordship.
No, I'm not on that also. The examination, exit examination by the PCI is with regard to your
B farm and
D Pharma.
D farm.
But they are holding it for D Farm and B Farm.
My lord, the Pharmacy Council of India will also hold for my lord,
B Farm.
yes.
You mean to say that any person
Yes.
from any institute, after completing his course, even from Shankardev University, will have to appear in that exit examination.
Shankardev University,
The PCI examination.
Yes.
All irrespective of whether from a
Yes.
private college, from a this, they will have to appear.
Yes.
Mr.
My lord,
There is time, we will issue notice.
No, my lord, in fact, there is another case filed by Girijananda University, their notice has been issued. They'll be filing affidavit there, but let me tag with that, my lord.
No, I just want to have one query.
Right.
Mr. You have issued this page 57 in terms of 7/11/20.
Yes, my lord.
Huh? Right? There is no other source of power? Right?
The question is how the autonomy of the private university can be taken away. Yeah, my lord, notice has been
Page
issued.
57 has been issued on the basis of page 45, my lord. That is the notification.
Page 45.
45. Because 57, my lord, this has been issued by the university on the basis of page 45. This is the regulatory framework issued by the government, my lord.
Okay. Page 54. Wait, just a minute. Page 50 is within that only.
Yes,
Yes, my lord, the offending clause is, my lord, serial number 1 down below. That is the offending clause in this notification.
Where?
Page 45.
Page 45.
For smooth functioning and to bring uniformity in administration of the health science courses, as mentioned above, all institutions imparting education in nursing.
I don't think so. This will come into. And you're conducting this institution not through another college, but you on your own.
On your
as the
own, my lord,
university
we are
itself.
empowered to, my lord, give degrees.
Degrees,
But
huh?
the requirement is that one examination has to be, my lord, passed. But why 2 examinations?
They cannot, Mr. Chaudhary, you go through page 50 and 51 meticulously. That power is not there. The government, it's trying to draw that power. That power under clause 10, the exit examination contemplated, is only in regard to nurses. And you come to clause 11, same thing.
Not for B Farm and B Farm.
These two, clause 10, clause 11, page 50 and 51,
Yes.
you
yes, my
could
lord.
not have issued page 57. See, check up clause 10, 1.
Compulsory pre-registration of internship.
Huh?
That was my lord.
Compulsory, that is with regard to nurses.
Yes, ma'am.
Now you come to 11, because they say 11 there. Now come to 11.
All candidates who pass out from the institution.
Read the last line. Read the last line.
The provisions supersede all other previous provisions and rules of registration of nurses.
And you come back to page 50,
Yes.
come down, there is a provision for pharmacy.
As per guidelines issued by SHUSH and respective councils.
So how can you now go back to this and hold an exit exam? Anyway, that's subject to what you argue. Same order will pass.
Yes.
Same order pass.
My lord, clause 11, last line, probably I'm pointing out, last line is regarding the nurses.
No. You come to clause 10.
10 is specifically for nurses, my lord.
No. You come to 10. 10D. After completion of internship and clearing of exit examination as laid down in section 11, the regular pass certificate shall be issued. And regular 11, you are now applying it across the board, but it's only contemplated for nurses.
No, 10 English 2 for pharmacy courses as per guidelines issued by SHUSS and respective council.
Not according to this. Not according to this.
Yes, sir.
Let them file affidavit. my lord.
Yes, my lord.
Clarify all this.
Highly obliged.
Similar. We'll pass a similar order.
Go to.
14,
Yes.
Please, Lord, please. This is my lord, relating to my lord, compassionate appointment, my lord. My lord, the petitioner, my lord, after the death of his father, my lord, immediately approached before the, my lord, Deputy Inspector of Schools, my lord, Borpeta. And thereafter, in accordance with the application filed by the petitioner, my lord, before the authority.
Your case was placed before the DLC.
Yes, my lord.
And the
On 9
DLC consider
2019, my lord.
you don't have a qualification with regard to assistant and there is no reserve vacancy available for grade 4.
My
What
lord,
more is to be done now?
but I have applied for, my lord, any post, my lord. But
They
in the-
considered in 2 posts. One is assistant teacher
Yes,
and another one is grade 4. They considered against both.
there
And
is,
your father, I think, had died in 2016.
right now, my lord, there is.
Today we are 8 years down the
Yes,
lane.
but my lord, in the year of 2016, I have applied, my lord, and thereafter on 17, my lord, they have
Show me the
forwarded,
law.
forwarded.
Show me the law. After 8 years, still you will have to be considered. Just show me the law.
My lord, thereafter, my lord, on several occasions, my lord, I was
You
waiting,
show
my
me
lord.
the law that even after 8 years, a right subsists for your compassionate appointment. Just show me that.
But my lord, I have applied, my lord, there it is the authority, my
Mr.
lord, they have
Counsel,
not.
I think I am within my rights to ask you that.
Yes, my lord.
So only show me one law that yes, even after 8 years or 20 years, I still am entitled to a compassionate appointment because I have applied within 1 year. We will have it at 2:30. You find that law form. Take the order.
My lord.
For order stay vacating item 21.
Yeah, please, your lordship. Lordship, here we are outside of the station, lordship. Kindly we pass over for the day, lordship. Here we are not, here we are outside of both, lordship.
Yes, what do you have to say? You are the applicant.
No, my lord,
You are the petitioner.
my lord, petitioner.
Hmm.
Angus
If
considered.
Mr. Bhuyan was out, you could have put in a small note yesterday. We would not have gone through the file.
Sorry, my lord.
This is not called for. We will have it tomorrow. Mr. Bhuyan is coming back tomorrow?
No,
When?
in Delhi, lord.
Huh?
At Delhi, lordship.
Delhi.
Delhi,
When is he coming back?
2 days.
Hmm?
After 2 days, lordship.
After 2 days. List this matter again on 27/3/2024 for further consideration. 27.
Item 22.
My lord, before my learned friend starts,
Who are you? Applicant, petitioner, who are you?
I'm with petitioner, my lord. I have
Then you
been
take your
my
seat.
lord, and my
Then you take your seat.
yes,
Let Mr. Abedin
yes.
begin. Yes, Mr. Abedin.
My lord,
You are Anil Kumar Roy.
yes, my lord.
Hmm.
This is the IA, my lord, arising out of this WPC 23.
You have retired in
Yes.
the meeting. Fine. This is with regard to provincialization.
Yes, my lord.
Your provincialization is stayed by this court.
Yes, my lord.
And you are a language teacher, admitted, right? You also admit that he is a social studies teacher.
Yes, my lord.
Huh? What is left?
My lord, the only thing, if your lordship looks at page 37
Of the writ petition?
of the IA, my lord.
Hmm. Hmm. Yes.
What I'm saying, my lord, I have been provincialized. I
Right.
serve, I serve,
No doubt about it.
I served.
Hmm.
I retired.
Hmm.
Now, only thing is that because of the stay order.
When did you retire? You retired sometime in 30/11.
On 30th November.
November. Stay order was passed.
Stay order was, my lord.
29.
6/5/2022.
6/5.
Yes, 2022.
So there was an order.
Yes, sir.
So we'll have to, in spite of your retirement, we'll have to consider
Yes, ma'am.
whether you were eligible. If you're eligible, you get it, or he comes in.
But the fact
The only
remains, my lord,
question now, this whole thing, without going into all these things, the issue is, what are you? You admit that you are a language teacher. He projects himself to be a social studies teacher. There is a clear pleading on your part that yes, he is a social studies teacher. Right? In this way, following 3/9, you being the second or the junior language amongst the language teachers, excess provincialization. So that has to be interfered with.
my lord, only one thing I would like to say at this stage. Rightly, my lord, first of all, that 3-year mark is not the maximum.
It's the minimum.
Yes.
Now, minimum, you will have to show that there is an enrollment there.
Yes.
Enrollment is not there. 100 and above. So that we can have more teachers.
My lord, in larger sense, that will also not come in, that enrollment part. If we take it in, because that issue has not gone into, though I tried in another case, ultimately the case was disposed of before those arguments could take place. My lord, what I am over here, if your lordship considers one thing, rightly, wrongly.
Be very careful, Mr. Deka. I don't know where he is taking me.
Yes,
Huh. Huh.
My lord, the line of argument was gone. I totally forgot now what I was supposed to say.
Because that was something he was creating.
It was the,
That much I can understand from his.
my lord, it was earlier days corridor site has come into my mind, my lord.
Yes. Mr. Abedin, nothing is here. Leave it. We can't help it.
No, but only one thing I'll say.
We'll make an observation if required, that in the event the enrollment in this college, in the school, so mandated, your case will also be considered
My lord,
with effect from 21.
my lord, only one thing I'd like to say, my lord. Rightly or wrongly, I have been provincialized. I work. It is not that I did not serve. Over here, the question of, my lord, further benefit like pension and all these things are not there. Only thing is there, whether I am entitled to get the salary or the payment, that is actually, it is the fixed pay as a tutor. Whether I am entitled to get that salary for the working period which I have worked.
You have not been paid
No,
from the date.
no. Because over here, my lord.
Now, that cannot be done for one reason. If that is done, that means the post gets attached to you. Right?
I've got for 3 months.
It gets attached to you.
Court is the
Now,
post.
once that post gets attached to you, he can never come.
My lord, what I'm saying.
That is why if this court is deciding, or even if the authorities are deciding, they'll have to go to the root.
My lord, keeping that in mind, I did not say the post is attached to me, though I have got the salary for 3 months.
We will say not to recover.
Because the minute one aspect is clear, that rightly or wrongly, I have completed the term, and whether the question of further benefit is not there, only that working period salary.
He'll consider.
My friend may come in, my lord. He can come in because now there is no embargo or any barrier, my lord. Because I have gone, I served. For take an example for a minute, my lord. My everything is wrong. My provincialization is wrong. Whether I don't want to disturb my friend over here. Whether, my lord, I am entitled to get the salary for the period I have worked because I was authorized to work, being provincialized. Right or wrong, your lordship will decide today, but in between I have already completed my
Yes,
service
Mr.
period.
Bora. What do you say? You illegally permitted him to work.
That is true, my lord. Actually, only one.
We will say whatever he is entitled, he'll get, but he will also get that from that date. You recover from your officers.
No, my lord.
Yes,
He
you
has
recover
not-
from your officers.
He has not provincialized, my lord, till then.
Why? You have illegally provincialized him, that I'll say now.
Yes, my
I'm
lord.
going to say that now. When I say that it is illegal, he was deprived,
My lord.
then it goes back to that date.
My lord, from day of provincialization, his service, he may be.
Cannot be. Moment he gets it, the post also goes with him.
My lord.
Post will not remain here.
There are two languages.
Anything more, Mr.
No.
We'll consider. You will have the orders next week.
Yes, sir.
God bless you.
Disposed of.
Deeply obliged. Deeply obliged. But the writ petition also is disposed.
All. Let's just put this inside.
My lord, I can maybe come past over time. She is coming.
Yes, Mr. Rava.
My lord, we have the instruction
For
Yes.
the
and the petitioner and the private respondents were also directed to file affidavit.
You were also direct.
My lord, as per our instruction, my lord, the remaining installations are vacated.
But she says that from one end to the other end.
Excuse me.
Where is Mr. Mullah? Thank you, Mullah. Thank. 12:14. Okay, both of them have said.
My lord,
The petitioner has also said that they are vacated.
yes, my lord. Even
What
the
is left
private
here?
respondent also. My lord.
What is left here? Where is Ms. Bora?
She is coming
Is coming.
for time.
Mr. Rava, just 2 minutes. Let her come.
Yes.
Moment she comes, ask her to tell her.
Maybe lordship.
Hmm.
Here, whatever.
Mr. Shama,
Yes,
one query.
yes,
Why should we entertain this application?
because my lord.
Because see,
Yes,
Sahidur may be eligible.
my lord.
The petitioners.
Yes.
Petition number 1 may be eligible. Petition number 2 may not be. Petition number 3 will have some other issue.
Some other.
May have different issues. Why together? Provincialization is something independent, pertaining to one person.
Of course, your lordship is right, my lord. Then when the petition was filed in 2019, my lord, those conditions were not so much adhered to by the court. Now, my lord,
And show me
my lord,
that you are claiming 2011, right?
yes,
Under the 2011 Act. Show me that your cases were considered and it was near finalization before the Act got stuck down.
yes.
Nothing
But,
is here.
no, what I am alleging here, my lord, discrimination. We were appointed in 1991 to 94, 95, 99. We appointed them and we were duly qualified on the date, my lord, 1/1/2013, when the schools were provisionalized from Assam, about 450 schools. And our school was also provincialized, but we are left out. We are left out.
on the plea that there will be some excess, he said. That's all. Otherwise, issue is same, my lord. It is a
No. Show us the law.
Hello?
Show us how we can come in now. How can we come in when the act provides for that?
Yes.
Hmm.
So we could be provincialized in 2013 itself before the act was struck down.
That is
It is-
academic now, Mr.
Yes.
Sharma, that is academic because that act is gone, something
No.
new has come in.
That has gone, my lord, it is not a repealment, my lord, it is striking down, it is unconstitutional. So section 6 of the clause act, general clause act will have come, certainly. Does it matter?
No, what I'm saying is 11, that episode is over.
Over.
We can't go back to 11.
No, your lordship will not go back to 11 so far as other cases. But in our case, what happened, we could have been considered 13 when others were considered.
Sharma,
There's some element of disagreement.
that unfortunately is the law laid down by this court.
Yes.
This court has permitted, after the even striking down of the 11 Act, to have regularizations made, provincializations made under that, provided everything was complete.
Yes.
Only the order was to be.
Yes.
Here, your cases were not considered. Then
Our case is not considered.
do one thing. You apply under the 2017 Act. All of you apply under the
Yes,
2000.
ma'am. That is the alternative remedy I am seeking orally, because my lord, if the 2013 Act goes, if it was repealment, why not, then I would be covered by section 6 of the clause act. Both the repealment would not affect my right. But now since it struck down as unconstitutional, then I was
That is gone.
my lord, and I was the lawyer in that case.
I know that.
In the,
That is why I was so up
Yes.
and going in asking you.
Yes. So, my lord, what I want was page 66 was paragraph 34. Just I want to realize, my lord.
Page 34.
Paragraph 34, page 66. Whether I can get some help from your lordship in that only. So far as the act is
66.
concerned, it is because here the question of treating equals unequally.
No, I'm sorry. This cannot be done.
So your lordship.
Because in your case, nothing had happened under that act.
No, we will
Then-
not consider. We will
then-
not brought in the parameter
So-
of the consideration.
So 10-4, under that act, 10-4,
Yes,
if your name was approved by the government,
yes,
but the provincialization order was not issued,
yes.
then this court has said you are deemed provincialized. But your case has not reached that stage. Posts were not created for you.
No,
Then-
frankly, yes. So, my lord, your lordship, your lordship, since your lordship is made up the mind on
No, I'm not made up of mind.
2017 Act, my lord, yes.
I'm
What I
not
am
made up
there-
of mind.
No, my lord, okay, my lord, I accept that 2017
No,
Act, they may be directed
You
to.
can always argue.
Yes.
I was just opining.
Yes. 2017 Act, we may consider what, and your lordship will kindly fix the time now, 3 months, 4 months.
That cannot be done.
My lord?
That cannot be done because we can only direct each one of you to make a representation before the director,
Yes.
and the director thereafter will take the matter forward.
And that director taking the matter, my lord, there should be some time bound. Suppose I make the application today, let him decide in the 3 months on my application. That's what I want.
Okay, done. That much we can do.
Yes.
Yes, Mr. Sharma, that much.
Yes, yes.
They'll make individual representations before the director, and the director will take the matter forward.
Yes.
Like
On individual merits.
on minutes. Mr. R.P. Sharma, Learned Senior Counsel, assisted by Ms. R. Devi, Learned Counsel, appearing for the petitioners. Also heard Mr. U. Sharma, Learned Counsel, appearing. The Learned Standing Counsel, Secondary Education. The petitioners, 48 in number, have joined together in the present proceeding, raising a grievance with regard to the non-extension of the benefits of provincialization of their services under the provisions of the Act of 2011, Pura Likh Dena, 2011, although under the said Act, the other eligible employees of the other serving teachers of the school were so provincialized with effect from 1/1/2030. The services of eligible teachers of the school were provincialized from 1/1/2030. On a query made by this court, Mr. Sharma has submitted that the cases of the petitioners herein were not considered and they were deemed to be excess teachers at that relevant point of time. Also, this court, although has noticed that the 48 teachers who have joined together belong to different schools and may have different issues with regard to their respective claims and or deficiencies in such claims, comma, joining together may not be permissible, comma. However, in view of the nature of the order sought to be passed in the present proceeding, the said issue is not entered into. Also, the provisions of the said Act of 2011 was set aside by this court on a challenge made to the provisions thereof. And thereafter, the government had enacted the Assam Education 2017 Act. Also, the schools of the petitioners, the respective schools of the petitioners having been found to be eligible for provincialization and serving teachers therein having also been so provincialized, comma, the cases of the petitioners herein are also required to be given a due consideration under the provisions of the said Act of 2017. Full stop. In view of the above position, the petitioners herein are required to submit individual representations before the Director of Secondary Education, Assam, claiming this, bringing on record their respective service particulars and claiming provincialization of their services. Provincialization of their services. Full stop. Such application be preferred within a period of 15 days from today. Huh? 1 month, within a period of 1 month from today. Full stop. The said application shall be filed by a said individual representation shall be filed by the petitioners along with a certified copy of this order before the Director of Secondary Education, Assam. Also, in the event the petitioners herein and or any of them, in the event all the petitioners herein and or any of them prefer such individual representations before the Director of Secondary Education, Assam, comma, within a period of 1 month from the date of this order, comma, the Director of Secondary Education, Assam, shall consider the said representations, and in the event it is found that the petitioners fulfill the requisite norms for having their services provincialized, comma, will have the cases of the petitioners verified, public scrutinized by the district level scrutiny committee, by the jurisdictional district level scrutiny committee. So thereafter, basing on the decision of the district level scrutiny committee, the Director shall place the cases of the recommended petitioners before the state level scrutiny committee, and thereafter, basing on the decision of the state level scrutiny committee, shall take appropriate steps for provincialization of the services of the petitioner. Full stop. The Director of Secondary Education, on conclusion of the above process, shall issue a speaking order intimating each of the petitioners of the reason, petitioners about the decision that was arrived in their cases by the respective committees, that is the district level scrutiny committee and the state levels. Also, the above exercise as now required to be carried out by the Director of Secondary Education shall be so initiated and concluded by the Director within a period of 6 months from the date of receipt of the certified of the representation from the petitioners along with a certified copy of this order. 6 months,
Can we do 4 months?
4 months from with the above observations and direction, the petition stands. Can't do anything much better than
That
this.
is better only. That is better and my lord, they will communicate.
I will do.
May I please, your lordship? Your lordship, I pray for passable for the time being, your lordship. Senior counsel is on his way, your lordship.
Hope he brings some
Yes,
good
yes,
news
your
along with him.
Yes.
Tell him that. We are waiting for that.
And you oblige, your lord.
Or we will be having very bad taste in our mouth because we'll have to pass orders to him.
Lordship is better.
Release this matter before any other court without me. I can't. I appeared for it.
Possible.
Ram Saran Bharali,
Yes.
Timoria College. Yes, Mr. Gula.
In this case, petitioner praying to get marks, my lord. Against two and wrong answer key given in the question, my lord, in TET examination.
Yes,
My lord, kindly peruse the order dated 30/1/2023, my lord.
my Lord Justice
My lord,
Michael's order.
regarding my lord, question number 133, my lord, we have taken the report of the
Sorry.
subject expert. We admitted, my lord, this against the option, against the question number 133, there is no correct option, my lord. And she is entitled to get the mark against
One
that 133.
You are an SC. You're
MOBC, my lord.
MOBC. So it comes to what, how many marks did this
Only
question
one
put?
mark she is entitled.
1 mark.
Yes,
So she gets 82,
82.
but still she's not true.
Yes.
What about that? Nirmala Prabha Bodlois,
yes, my lord. The correct option is actually, my lord, option A, my lord. Only,
she
my lord-
gave B,
Yes, my
but
lord.
there is a spelling mistake.
Yes.
Only Ritu and
Rati
Rati.
in place of Ritu.
Ritu, yes, ma'am.
How do you handle that?
My lord, against who had put this option, my lord, A, those candidates are awarded, my lord, 1 mark.
And you have treated that to be a correct question.
Yes, ma'am.
Only who have given A, they have been marked,
Yes, ma'am.
and B has not been marked.
No, my lord. She put on in the option B, my lord.
She put B.
B.
Yes.
My lord, there is no negative mark, therefore she opted that both the
Lord, entitled to 1 mark, my lord.
1 mark, yes, 82. But what will you do?
Yes, ma'am.
1 mark will take her now nowhere. Now, if I have to give you 1 more mark, I'll have to give everybody. I'll have to hold that the question is wrong, which I cannot. And the law now is very clear. Yes, Mr. Roy, what to do?
My lord, as per my lord,
Only these 2 questions.
yes, my lord.
my lord, the petitioner already put on the wrong option B, my lord.
So 33, she is not entitled.
Not entitled.
133, 1 mark. 133, 1 mark,
Yes, ma'am.
82. Yes, Mr. Talda,
I know.
you're putting your head down. Why? What to do? Give us a way out.
My lord, pass now.
What to do? Yes, Mr. Roy, what do you want to say?
My lord, SC, my lord, put on the wrong option, my lord, B, my lord. She is not entitled to get the 1 mark against question number 36.
That's it.
And against the 133, my lord, she is entitled because correct option is not there. my lord.
Done. Mr. Talda, anything more?
No, my lord.
Nothing more? Yes, give me a way. Give me a handle.
Exercise, কোনো করে।
In that question, my lord, your lordship may grant a 1 mark because
We can't do that.
exceptional. my lord.
Supreme Court is very strict. This has been very stringent in this point. Nothing doing.
Then up to your lordship.
So, lega. But Mr.
Okay, Kolisa.
A. Kulta, Learned Counsel for the petitioner. Also heard Mr. B. Talukdar, Learned Standing Counsel, Elementary Education Department for respondent numbers 1, 2,
1, 2.
and 3. Heard Mr. D.K. Roy for the respondent number 4. Sarva Shiksha Vision, why did they were brought in something? They are involved. They issue the certificate.
Yes.
Who appears for Sarva Shiksha? What is your name?
Age Burma, my lord.
H. Borua, Learned Counsel represents the SSA, Assam.
27.
Assam.
28.
The grievance raised in the present proceedings is by the petition is the non-grant of marks to her against the Assamese paper for a question for question number 33 in Assamese paper and question number 133 in 133 in Assamese paper, and that is how much? Maths?
Maths.
Question number 36 in the mathematics paper of her teacher eligibility test Assam examination 2019, right?
Yes, my lord.
Full stop. No, I put it like this. Just correct. The petitioner, the present proceeding has been instituted by the present petitioner as alleging that on account of wrong answer keys, with regard to questions number 36 and 133 of paper 1, bracketed Assamese stream pertaining to the Assam State Teachers Eligibility Test for lower primary schools, the petitioner was deprived of 2 marks and accordingly she was declared to be not qualified in the said examination. The petitioner had participated in the said examination 2019 and had secured 81 marks out of 150. Also, the petitioner being a candidate belonging to the MOBC category, was required to secure 83 marks out of the set 150 marks for qualifying the set TET exam, for qualifying in the set TET examination. So the petitioner secured 81 marks. The petitioner instituted the present proceedings, questioning the answer key with regard to two questions. That is question number 36 and question number 133 of the paper 1 bracketed as a mystery. So the questions being relevant, the questions along with the options thereof being relevant are extracted here in below. Page 17, you will get question number 36, order sheet, and page 18, you will get question number 133. Also, it is seen that with regard to question number 133, the answer key has reflected option A to be the correct answer. However, it is contended by the petitioner herein that she had opted for option B. Also, the petitioner further contends that the set question, the option A for the set question was wrong in as much as in place of Kudirgo Din Aru, this one, just see here, A to A. It is within this only. Kudirgo Din Aru Rati, apostrophe. It was projected as Kudirgo Din Aru. Din Aru Ritu. First is Ritu, next one will be Rati. R-H-E-A. Right?
Yes.
Full stop. The said error, according to this court, is a typographical error and does not go to the root of the matter. And accordingly, the petitioner not having opted for option A against question number 133, she would not be entitled to any marks against the same. So, with regard to question number 36, the learned counsel for the Board of Secondary Education Assam has placed before this court an opinion received from the professor and head of department mathematics with regard to the options as given against the set question, which pertains to the mathematics subject. So, on perusal of the opinion of the expert, it is seen that all the options that were laid out against question number 36 were wrong. Accordingly, the petitioner and all others who had participating in the set examination would be entitled to 1 marks. Also, in view of the above, the petitioner would now be entitled to have 1 more mark added against the mathematics subject, raising her marks from 15 to 16, and consequently, the total marks of the petitioner would now stand increased to 82. Also, however, the petitioner still would not meet the cutoff of 83. This court would not like to proceed with the matter any further. And by making a declaration that the petitioner is entitled to 1 more mark in the manner indicated above, this petition stands disposed of. Do whatever you want. The opinion as submitted by the communication dated 13/1/2023, containing the opinion of the expert as submitted by Mr. D.K. is kept on record and marked as X for the purpose of identification. Disposal. Timing matter after. you go ahead. What happened? Became Andakar. Yes. Yes.
Only because of having my lord, no dice lordship, my lord, claim was not considered lordship. So it may be disposed of directly to my lord as
But
because
now,
of question of
how
dice.
can
is there.
how can they give you a dice from 2009 today?
My lord, in absence of dice, my lord, can also be considered lordship. Because I was not defaulted lordship.
It can be
School was
considered.
not defaulted.
1311 is there. But why did you not apply for a dice at that point?
I applied lordship.
Then
Applied several representations kindly.
have you come before this
In
court
time.
before this proceedings?
No lordship.
Yes, what is
My
your
lord, we
stand?
have our instruction, my lord. May I able to produce before this honorable court?
You are having instructions, you should
My lord, we like to file a
Bold.
court affidavit, my lord.
bold.
My lord.
Why request? When did you first apply, Mr. Abdul?
Minor application for dice lordship.
Hmm.
It was on March 17/10/2009 lordship.
Why not before that?
Page 15, my lord. See, there I approached my lord to, my lord, to.
So where is
issue
that
the dice.
material?
My lord. Page 13 is the, page 15 is the first representation lordship.
When were you given recognition?
My lord, recognition, this is inspection report, it is not recognition lordship, LP is.
When was your LP school? There is no recognition required.
Lordship. Permission is there. lordship.
Permission. Very
Yes.
sorry, permission.
Permission, my lord, inspection report is there, lordship. Page
Now,
13.
where is the permission?
Permission is not, my lord, next, my lord. But the inspection reports kindly see, lordship.
Mr. H. Burwa, Learned Standing Counsel, assessing, submits that he has received the instructions in the matter and would like to file an affidavit thereon. File an affidavit in the matter. Full stop. List this matter again after 3 weeks, enabling Mr. H. Burwa to bring on record the stand of the respondent authorities in the matter. The respondent SSA in the matter. Full stop. The respondents in the elementary education department shall also file their affidavit in the matter dealing with the issue as raised by the petitioner hearing and also bring on record the fact as to when the said school had started functioning and as to whether the school was functioning continuously after being set up by the people of the area. Also, list this matter again after 3 weeks, Likana.
Highly obliged, my lord.
Let them come on.
Loss, obliged.
31.
Yes, Mr. Chakraborty.
Lordship, this petitioners were claiming some area verification. Now, this Lordship, the petitioner died about 2 years back.
Right.
Lordship, I couldn't contact his family.
You
also
bring
to
his
substitute.
substitution.
Lordship may close it, keeping the option open. I am unable to contact his family members, Lordship.
It has been submitted at the bar by Mr. B. Chakraborty, Learned Counsel for the petitioner, that the petitioner hearing had died around 2 years back. So it is the submission of Mr. Chakraborty that he had tried all means to have the legal heirs of the petitioner substituted in the present proceedings. However, on account of not receiving any response from the legal heirs of the petitioner, he is not in a position to move further in the matter. Also, in view of the above position, this petition stands dismissed
Closed.
for non-prosecution.
Lordship may close it.
For non-prosecution. However, it is left open. However, the legal heirs of the petitioner are at liberty to file appropriate application for revival of the present proceedings.
Lordship,
If they come back, because he's entitled to something.
certain benefits.
Because that post is there from 93 and you had upgraded him. Why not pay him?
It's fixation of that period.
Period. They get some amount. Yes.
20, my lord. This is the minutes of the DLC, my lord. Whereby the petitioner school was recommended for provincialization and
The heard Mr. B. Rahman, learned counsel for the petitioner. Also heard Miss Sutia, you are appearing.
Minor.
This is what elementary.
Elementary.
Elementary. Miss S. Sutia, learned standing counsel, elementary education department for the respondents number 1, 2, 3, 4. Mr. B. Dury and appears for respondent number 5 and 6. The grievance raised in the present proceedings by the petitioner is that the present petition is that the eligible serving teachers of the school, the cases of the eligible serving teachers of the school have not been taken into consideration for provincialization of their services. Although the school in question was declared to be eligible for such provincialization. What is this 4/2/2001? Okay.
that is the
Where is
notification.
also the learned counsel, the full stop, the petitioner's content that the cases of the petitioners were considered under the provisions of the Act of 2011 and their respective the cases of the eligible serving teachers of the school were recommended by the district scrutiny committee. However, the said process was not taken to its logical conclusion, and in the meantime, the provisions of the Act of 2011 came to be set aside by the school. It is further contention of the petitioners that after the enactment of the Act of 2017, the cases of the petitioners were not considered under the provisions of the said Act, although schools which were established much after the establishment of the petitioner school have since been, other employees therein have since been considered and provincialized in their respective services. Full stop. Accordingly, the petitioners pray that their cases for provincialization under the provisions of the Act of 2017 be considered and be considered. Full stop. In the view of the nature of the grievance raised by the petitioners here, the petitioners are required. Petitioner school, the serving teachers of the petitioner school are required to approach the director of secondary education, director of elementary education, by way of filing a detailed representation and enclosing the particulars of each of such teachers in the format prescribed. Within a period of 15 days, or within a period of 1 month from the date of receipt of a certified copy of this order. Within a period of 1 month from today. So the representation, individual representation along with a certified copy of the check. So in the event the director of elementary education is in receipt of the representation from the serving teachers of the petitioner school along with their respective particulars, the Director of Elementary Education shall have the cases of the petitioners scrutinized by the jurisdictional district scrutiny committee, and thereafter basing on the recommendation of the district scrutiny committee, further processing of the matter for placing it before the state level scrutiny committee shall be so done. Also, the recommendations as received from the state level scrutiny committee shall be communicated to the petitioners by the Director of Secondary Education. Also, the cases of the petitioners who have now been found, who would be found eligible for provincialization of their services by the state level scrutiny committee, their cases would be further processed and orders provincializing their services shall be so issued. Also, with regard to the cases of petitioners annulled, the above exercise shall be initiated and concluded by the Director, Elementary Education within a period of 4 months from the date of receipt of the representation, along with a certified copy from the petitioners. With the above observations and directions, the petition stands.
33.
Your Lordship, this petition is for reinstate the provincialization status of this school. The last occasion,
You file an affidavit.
notice was issued for file an affidavit, but they have.
Mr. H. Borua, let him file an affidavit, Mr. Mr. H. Borua, Learned Counsel, appearing for the SSA Assam, prays that he be granted for the 3 weeks' time to bring on record the stand of the said authority. Also, accordingly, list this matter again after 3 weeks on a date to be fixed by the registry. Also, Mr. Borua shall ensure the filing of the affidavit before the next date fixed. Also heard Mr. Asidas, Learned Counsel, appearing for the petition.
Can I take a photocopy from the second?
Hmm?
Can I take a photocopy of the second?
No, you're not permitted to take it out.
34.
You are a veteran now. Hmm? Yes, Mr. Ghosh.
Actually, this is against the provincialization service of the private respondent number 5, my lord. Now,
6.
Here, my lord, now affidavit has already been exchanged, my lord. Pleading has been exchanged. My lord, initially stay was granted, my lord. You filed an application for vacation of the stay also, my lord, private respondent. That was also dismissed.
You are for the private respondent.
I'm for the petitioner here.
Okay,
My friend is appearing for the private respondent. Now here, my
Yes.
lord, under 3.1.11 lordship. That my lord, one teacher lordship is from the science, one is from the.
What is your name?
My name is my lord Sajan Ali. I
Petition.
belongs to social science stream.
And Mr. Abedin is appearing for?
Yes,
6, Aisha.
she is a language teacher, my lord. 2 language teacher has been provincialized, 1 science teacher has been provincialization, barring my lord. Myself, I am my
Social
lord.
studies.
I belong to social science stream, my lord. So against that, I have came. So that is in my lord, the prima facie violation of 3.1.11 lordship of the 2017 Act laws. Your lordship now wants this matter, my lord. This court has already taken cognizance of the all, my lord. Reading has been.
You'll have it at 2. We'll finish.
Lordship.
Mr. Abedin, any problem? You have the records with you? Because I think, Mr. Abedin, subject to correction, you have taken a plea that the projection that you are a Arabic teacher is not correct. Right? Have you taken a plea?
No.
You are an Arabic teacher.
Yes,
I've taken the plea that he is a social science teacher. I have not occupied his post. I am an Arabic teacher and I have been given the benefit, and
So who is occupying his post?
nobody.
It's vacant.
Yes,
not, but there is 3 posts, but 3 person has been appointed.
that is the wrong concept always.
Yes.
My lord, if we
I
Well,
cannot be
let's-
deprived of the social
My lord,
rights, my
let's
lord.
change it little bit, my lord. The school is directly merged with the base school. As far as the document concerned over here, it goes to show that the base school had only 5. Requirement is 11 after the. I think, my lord, they should have filed an, even section 14 can take recourse also, my lord.
List this matter again for further hearing on 27/3/2024. I don't want to go up at 3 today. We'll go on 27.
My lord, make it 28 Thursday.
28.
No, no.
That day we will clear your this query.
Yes.
After-
35.
My lord, if it is second half, your lordship will excuse on that day also.
Huh?
If it is second half,
Ah. I got it.
will not be able to.
No,
do
no,
it.
no, I got it. I got it. Just make a mention,
Yes, my lord.
13 laws.
Deeply obliged.
but not excused for the first half.
Definitely not, my lord.
On page 21, under the District Scrutiny Committee recommendation lordship,
Page?
21. My lord, this is the, my lord, next page is, my lord, page 22, my name was recommended, my lord. Serial number 3, Mahmuda Khatun.
Mohammed Khatun.
Mahmuda Khatun.
Yes.
My lord,
Wait.
Arabic estate, Arabic teacher lordship,
This is item number 35.
35.
Hmm.
My lord, finally, my lord, my provincialization is not there lordship.
Yes. 3 posts have been given. You don't have posts. What is there?
At least 3 posts, my lord.
3
More
posts
than
are
three-
given. 1 science teacher, 1 social, 1 language.
That is as per my lord, section 3 lordship, subsection Roman 11 lordship. It is at least 3, my lord.
3.
My lord, more than 3 can be given, my lord.
You have your, show me
This
the
is
law. I can't go beyond.
classical teacher.
You challenge that 311.
Well, classical teacher.
You challenge 311. We can't.
No lordship. 311 because in my humble submission lordship.
That is what Mr. Abedin was trying to take me
In
through.
my humble submission, at least 3, my lord. More than 3 can also be, my lord.
If the enrollment status mandates, why 3?
It,
10
my lord,
also.
section 311 does not say that more than 3 cannot.
You can't read 311 isolation. You will have to read the other provisions of RT Act also.
My lord, RT Act, my lord, this additional teachers lordship.
I'm sorry,
Additional
nothing is yet.
RT Act, additional teachers, my RT Act, my lord.
We'll make an observation that in the event there is a requirement for additional teachers, the government may proceed in the matter in accordance with law.
My lord, then I may be allowed to file a appeal lordship. I'll file a appeal that may be directed to be disposed of as per section.
I'll not. If you want, you withdraw, I'll permit you to go. Otherwise, this-
section, you
because
lordship-
I'll have to hold
My
that that the provisions, and see, none of them have been made party respondents. So you have got no claim against them.
Against others, my lord, I have no.
No,
grievance.
then if it is a fresh post, you don't have a case.
Now recommendation is there, lordship. My lord,
Recommendation may be made, DSC, but the government has to do in terms of the policy and go beyond that. If you want to file an appeal, I'll permit you. But I'll not on merits.
my lord, that may be directed to be disposed of. Your lordship has also disposed of in other cases, lordship.
I will direct that, but you will have to withdraw this. I'll direct that.
On merit, after hearing, it can be directed to be disposed of, lordship.
You withdraw it, I'll allow you to go there and I'll ask them to also
Then
consider.
I'll have to, I have to take instruction whether.
Withdraw. I will pass orders on merits. 2 o'clock. Right, 2 o'clock.
Lordship?
2 o'clock. We'll pass
No,
orders on
some
merits.
other day, lordship.
Huh?
Some other.
No, 2 o'clock. Nothing is there.
Lordship.
2 o'clock. On 16/1/2001, the petitioner was teaching the Arabic subject in this at school. Full stop. It is the contention of the petitioner that the cases of the serving teachers of the said school were taken up for consideration by the respondent authorities for provincialization of their services under the provisions of the districts, under the provisions of the said Act of 2017. Also, in pursuance to the process as mandated under the said Act, the services of 3 teachers, that is Abdul Kalam Azad, Amir Hussain, and Nasiruddin Sheikh, were regularized as, were provincialized as tutors in the said school. So it is seen that the teachers were provincialized against the subject of language, social science, and science. Stop. It is the projection made that the case of the petitioner, although was required to be so provincialized in the said school given the enrollment status therein, her case was not considered, although the petitioner was serving in the said school since (16/1, 2001). In this connection, it is relevant to note the provisions of Section 3, subsection 11, which mandates that in a venture upper primary school, minimum 3 teachers or tutors have to be provincialized. Services of 3 serving teachers have to be provincialized either as teacher or tutor, and at least 1 teacher out of the set 3 must be for the subject of A, science and mathematics, semicolon B, social studies, and C, languages. So, in the case on hand, it is seen that the provisions of 311 has been complied with by the respondent authorities, and the petitioner has also not assailed the provincialization as so effective in the case of the persons named here in above. So, in that view of in the above view of the matter, there being no allegation with regard to the provincialization as effective in case of the 3 serving teachers of the school, which has been held by the school to be in compliance with the provisions of 311 of the said Act of 2017. Further, the petitioner is not entitled to any relief in the present proceedings. Full stop. Accordingly, the writ petition stands dismissed. Full stop. However, considering the submission made by Mr. M.H. Ahmed, the counsel for the petitioner, that the school has the requisite enrollment status, warranting sanctioning of 1 more post of assistant teacher, the dismissal of the present writ petition will not stand in the way of the petitioner preferring a representation in this connection before the Director of Elementary Education, staking her claim for an additional post being sanctioned to the school by establishing the requirement for the same basing on the enrollment status of the school as on the date when the same was considered for provincialization. In the event of any such representation being preferred by the petitioner, the same shall be considered on its own merits in accordance with law. Pillu?
My lord, I had instruction, my lord. My lord, to not to proceed at this test lawsuit. Now,
No, not to proceed, not you, me. I said that's my view.
my lord, section 3 is my lord under consideration of the Honorable Division Bench law.
Let it be. One comes where you come back, you file an appeal. This will also get tagged. But as on date, we
My lord,
find
that
this is
observation may be given in this case.
Huh?
That observation may be given
What?
in this case. My lord,
that you have to go for appeal.
subject to the, my lord,
No.
Division Bench order lawsuit.
Deeply obliged.
My lord, not entitled, my lord, it is, I have not made it not entitled lawsuit.
Who? I say that you are not entitled.
Lordship, that is why lawsuit. My lord, in the meantime, Division Bench, my lord,
If the division bench comes, that will be 3+. If it is 3+,
yes, Lord.
the subsequent direction will cover you.
That observation and subject to my lord, Decision of the honorable division bench lordship.
We can't go beyond our area. Let us remain in our area.
Lordship, I would like.
I've given you that other part.
Yeah.
You exercise that. Yes.
And the record is in vernacular, my lord. Record is Hindi.
You read, I will hear.
No, that is not possible.
You're Union of India, you should know that.
Yes, my lord.
You read, I'll hear.
Under the petitioner, he was serving in the Central Reserve Police Force.
Second proceeding is bad.
No.
Not
even,
bad.
even if the second proceeding remains,
Hmm.
even if the similar, the bad portion, when I go to argue for the inquiry officer for this and that, all that arguments can be made, but this person has already retired from service.
Retired.
He voluntary retirement he has taken, he's at home. So.
How
only-
is this period? Last known period treated?
That is what I was coming with, page 97 of the writ petition if lordship has. I will only argue on a short, I'll keep it as short as possible. Page 97, lordship has. The period of suspension of CTGD Bhimram from, lordship will kindly have the dates. 18/12/06 to 14/1/2008 shall be treated as such and he shall not be entitled to any amount other except the maintenance allowance. So this remains a part of his service even as suspension, no difficulty. Now, the period on which he was absent, allegedly absent, that is 12/5/06 to 17/12/06. And the other period is 15/1/08 to 1/1/30.
This is the period of your detention.
Conviction.
Conviction and detention.
Detention. And finally, stoppage of increment for a period of 3 years with cumulative effect. Now, what I have discussed with the client is, since he's retired, if the diagonal goes, if the cumulative effect goes, it will give him some relief in the pension part. Whatever pension.
The first part of your prayer can be accepted. Second part, no.
Which one? Which part?
That diagonal should go.
Diagonal will go because there are certain judgments I would like to, if I'll try to keep it as short as possible. If lordship is convinced, I'll have my relief.
But your second part.
Which part, my lord?
That increment.
Increment
we are
is
not-
settled by this honorable court, my lord. That is also settled, my lord. Increment, I will lose.
Oh.
Cumulative effect,
Show me.
will have to go.
Show me.
That is what. The first judgment lordship should have. The page to Bhavaname, set to Jennifer. First one, my lord, is a judgment of 2014.
2014 one PLR.
GLR 175.
Hmm.
My lord, lordship will have paragraph 18. On the second page, paragraph 18. The question for consideration is whether the period of suspension, more particularly the period commencing from the release of the petitioners from custody till the order of compulsory retirement, should be treated as diagonal.
No doubt of it. This, I am with you.
It has to be.
I'm with you.
Therefore, if lordship will find
I am with you with regard to the diagonal. Come show me the, with regard to that
Compulsory.
other penalty.
the,
Cumulative effect.
their lordship will kindly have the next judgment I have given Rahul Kumar.
Hmm.
Their lordships will kindly have paragraph 10, my submission, what I had made. Mr. So-and-so further submits that the penalty imposed, namely stoppage of annual increment with cumulative effect for 1 year, is not prescribed under the act or the rules, and therefore the same sense vitiated for want of jurisdiction. Mr. So-and-so, learned counsel with the petitioner relies upon the decision of the Honorable Apex Court reported in so-and-so
State Bank of India versus TJ Paul to buttress his contention that in absence of specific prescription in the rules, a particular penalty cannot be imposed, and on that count alone, the impugned penalty of stoppage of annual increment with cumulative effect is not sustainable. And Lordship will find at paragraph 15. I'm sorry, madam, not paragraph 15, paragraph 14. It is seen that the Act does not prescribe for the penalty of stoppage of annual increment with cumulative effect. However, in the rules framed thereunder, namely the CRPF rules 1955, more specifically Rule 27, the procedure for imposition of punishment is laid down. In the table appended thereto in serial number 7, stoppage
CRPF
of increment finds place. However, even in the rules, there is no mention about cumulative effect. The difference between the penalty of stoppage of increment and stoppage of increment with cumulative effect
CRP effect.
is a major difference, where the latter penalty is even more severe than the stoppage of increment is for all times to come. Then my lord would have paragraph 16.
Yes, continue.
Paragraph 16. Future prospect of the petitioner is relevant factor to be considered while taking a decision to impose a penalty in a disciplinary proceeding, which is seen to be done in the instant case. However, the penalty imposed of stoppage of annual increment with cumulative effect for 1 year, apart from being harsh, vis-a-vis the nature of charge charged with the explanation, is not a prescribed penalty either in the Act or the rules. As held by the Honorable Apex Court in the case of State Bank of India Supra, the authorities cannot impose any penalty which is not one of the enumerated penalties in the rules in force. This court, exercising powers under Article 226, can in appropriate cases mold the relief to minimize the litigation, the time undertaken in such litigation.
CRP.
In this connection, so and so.
CRP.
Thereafter, my lord, paragraph 17, subpara 1, the punishment of stoppage of annual increment for 1 year would be without cumulative effect. And my lord, finally, my lord, that diagonal part, another issue that I would like to just point out, my lord, the third judgment, Subharam Hazarika, before treating it to be diagonal, a notice was to be there. That notice is admittedly not there. So what I would praise that diagonal goes, continuity in service remains, cumulative effect goes, 3 increment stoppage remains, and his pension be accordingly, my lord, calculated and disbursed. Others, my lord, I will not lengthen the argument much.
So, if there is no prescription with regard to cumulative, non-cumulative, you can't make it cumulative. Give me that CCA rules. Test it.
CCA rule. That I'm not feeling it. So
No, you know, we have it here. But you're getting like CCA. I do.
It is there in the CCA rule. Cumulative effect.
I think so.
It is there. It is there. Rule 11. But not in the CRP effect.
We don't have it in our rules, the state rules.
For them also, some argument could be there.
But you have reams and reams of case laws.
My lord.
You have reams and reams of paper case laws upholding that.
Well, in fact, in one judgment, I have not brought to the in one case, this honorable court Justice has held that CCS rules will not apply. That is not entirely correct, of course, but there is a judgment which says that I'm not relying on that as of today. Rule 11, if I'm not wrong. No, Rule 11. 14, 15, 14. At number. Yes, Rule 11, penalties. Only withholding of increments of pay at Rule 11 would be a minor penalty, while if it is with cumulative effect, it becomes a major penalty.
And the CRP effect, major penalty is under?
27, all penalties under 27. Rule 27. Rule 27. There is only a table which cites the penalties. At 27, serial number 7 will be stoppage of increment. It's classified as minor in the CCS.
Come to rule 27.
This one, remember.
3.
Reduction. Reduction is a different issue.
No, read it.
Reduction to a lower stage in the time scale of pay for a specified period. Reduction, that reduction has to take place. The order is not one of reduction.
Your withholding of 3 increments
My lord.
together
My lord.
amounts to a.
No, it does not. Reduction will be when I'm drawing something and I am brought down one stage. That will be reduction.
You come to the CCS rules.
Yes, my lord. CCS rules.
Rule 11.
Rule 11, yes. my lord. Two separate laws you will find rule 11. Subrule 11 is 11.2 is, I'm sorry, subrule 3, 11.3 is 4 is reduction to a lower stage in the time scale of pay, and 4 is withholding of increments of pay. Separately given. In fact, separate 11.
Reduction 3A.
3A.
Reduction to a lower stage in the time scale of pay for
by
a
one
period
stage
not
for a
exceeding
period
3
of-
years
Huh.
without cumulative.
So that
Wait,
reduction
and not adversely affecting his pension.
tension.
Save as otherwise provided in 3A.
That is my lord.
Reduction to a lower stage
Yes,
in the time scale of pay
my lord.
for
a
a period
specified
specified with further direction as to whether or not the period for what so and so, so and so. So here
So,
in this central rules,
my lord,
you don't have a penalty called withholding of increment.
it is there. 4, 11.4,
Okay, increments of pay.
11.4. And my lord, if lordship has
We don't have a penalty to that effect even in this also.
then that will remain, my lord, that they did not do. I will not be, my lord, answering.
Okay.
Lordship will kindly have one judgment. Only like it. MR Punjab. I'm so sorry, my lord, one judgment I just mixed up. It was RK Goel versus Punjab Electricity Board, where the Supreme Court has totally differentiated between withholding of increments
Increment and-
without cumulative and with
RK
cumulative.
Goel.
These are two different things. man.
Yes.
RK Goel versus Punjab State Electricity Board. if I'm not wrong. So one is a major penalty, one is a minor penalty. That aspect will always remain. Otherwise, this honorable court has held that when the cumulative part is not there, you cannot impose that. And lordship will find.
Yes, Mr. Mehdi.
Well, basically, my lord, the Dinubu inquiry, my lord, it was not challenged, my lord. Dinubu inquiry, my lord. The prior person, my lord.
And
They never challenged the Dinubu inquiry, my lord.
Dino way. Fine. Have you heard what he has said?
But there is no prayer to set aside the.
No, have you heard what he has said, what he has submitted? He is not, he is saying that penalty is okay. Proceeding is okay, but the penalty you have imposed upon me is not in connoissance with the rules.
Other part, super down, this part, my lord, is not. This, in the affidavit, my lord, his absence period, my lord. Absence period, my lord.
That is known.
Yes, my lord.
Cannot. You cannot. He was under detention.
My detention was.
You knew about it.
Yes, my detention was, my lord, he was in a criminal case, my lord.
Be that as it may, he was acquitted.
On the benefit of doubt, my lord.
Be that as it may. Be that as it may.
Because,
See, he was acquitted, that's why you gave up charge number 2, second round.
yes. My lord, only my submission, my lord, before this honorable court.
You submit with regard to his submission with regard to penalties.
Because this, he was reinstated, my lord, as part of the acquittal part, my lord. As part of his acquittal part, he was reinstated, my lord. But so far, my lord,
That is known, this court will come in favor. But with regard to that cumulative thing, what do you have to say?
The man, my lord, is who is on the service, my lord, during that
Mr.
period.
Mehdi, what does your rule say? Whether it supports that, we are ready with you. We just show us that he's saying is that simple withdrawal of increment, fine, no problem. But this penalty cannot be.
Factual case of the cases, my lord, is, my lord, even, my lord, his initial from the death. my
Tell
lord.
me whether you can impose penalty with cumulative effect. Just answer that question. Rest will follow. Just give me that. Where is your power to impose penalty with cumulative effect? I'll have to wait. Okay. We will read. He has already given this much confusion. We'll try to clarify this.
I've not gone through the judgment.
You need not go.
Should I give Rajkumar Goel, madam?
Just give me the citation.
Yes, madam. Rajkumar Goel would be 2014-15 SCC 748.
748.
748. My distinction drawn is punishment, stoppage of increments with and without cumulative effect. Stoppage without cumulative effect is a minor punishment. Stoppage with cumulative effect is a major punishment. And end of the judgment matter, they say that
There is one more
High Court
judgment
of
referred to
Delhi.
there. Just see, there is another Supreme Court judgment referred to there in this?
no, yes, Ranganath Rai versus State of no, that is PN.
No.
No.
Or
Supreme
maybe
Court
Goel was the judgment.
Goel, and they refer to Punjab and Delhi High Court judgment
Delhi.
saying that this is the correct view. That is how it happened. Well, since his retirement, fighting out the other part is now not necessary, is what he has told me. But if the pension is corrected, he stands indicate.
Well, tomorrow, my lord, I'll do that. So for cumulative effect, my lord,
You file a written statement by tomorrow, written argument by tomorrow.
yes, my lord.
Disposed of today, file a written argument.
Yes, my lord.
Judgments, I'll pass the orders during the Holy Weeks.
Yes.
But something public, let's see.
Yes, my lord.
Something, not
My lord,
somehow it's not coming. Let's.
when my friend is not, my lord, creating the trouble.
No. Friend will not create trouble. Something is some proposition somewhere which somehow is not coming. It'll come. Let's see.
Obligation.
Otherwise, dice not gone. Dice not gone. Cumulative effect subject to my.
Yes, my lord.
Well, also, may I like to have that Rahul judgment, my lord, it is discussed. Why?
There is
And
a
the-
Supreme Court somewhere.
The
Let's see.
Supreme Court order also made with that the penalty, if it does not say that that they had removed the person from service. Supreme Court said that dismissal was a punishment. Removal was not a punishment. You could not have given removal to.
We have orders here. Discharge is not a punishment. Dismissal or removal is a punishment.
But then,
We have judgments of this.
Madam, in that other judgment that was referred to by the Supreme Court, in the Supreme Court, madam, they had said that the person was actually removed from services. So Supreme Court said the punishment given is the punishment enumerated is dismissal. When you don't give him dismissal, you cannot use removal because it is not an enumerated punishment. And following that, my lord, our honorable court has
No,
said
otherwise I am bound to.
cumulative is not there, cannot come in.
It would be like that. Your CRPF.
And obliged.
My hands were tied. But I think I have justified it towards the end of that order. The manner in which it should be dealt.
Obliged.
Item 3.
Yes, Mr. Chaudhary. 2 points. First is that maintainability.
Flush.
Manipur, everything. He says that now that he's staying here, so he'll have a jurisdiction. If that be so, then any proceeding initiated here, man from Kerala, man from Tamil Nadu, after the proceeding goes back, he will be instituting the proceedings there. Because Union of India. Right?
Question is, Lordship, after he has been removed from service. Now he is here.
That's what.
Now he is here.
Mm.
That is his statement.
Mm.
In the case. His appointment was in Manipur. His termination was in Manipur.
His selection was in Manipur, appointment Manipur, proceeding Manipur, termination.
Everything Manipur, and he's from UP. After being terminated from service, he has started to reside here. Then so that is too fast.
Too fast.
And
And there was a case, similar issue was taken up. I had the occasion, I was appearing. They had taken a plea that this man was, I don't know whether the matter is still pending. Man was from, he was having the proceeding in Rajasthan or somewhere. He came back to his house. He preferred an appeal from here. And that appeal was rejected, the communication was made here. So this court said, no, jurisdiction is there. Because a part of that cause of action arises. You don't have.
In my case, that is not.
There.
Lordship, perhaps my friend was referring to Khajur Singh.
Mm.
This is a subsequent judgment of 2004.
Mm.
If I may take your Lordship to paragraph 8 and 9
Mm.
at page 4.
Mm. Mm.
8, 9, and 10, I think perhaps Lordship, that is the
9, 10, that is what?
that is-
Para 10. Keeping in view the expression used in clause 2 of 226 of the Constitution of India, indisputably, even if a small fraction of the cause of action accrues within the jurisdiction of the court will have jurisdiction. We will not go further. We'll pass on this.
In fact,
Dismiss.
only prayer is that, my lord. Your lordship today hearing may be completed, but I will submit short argument, my lord. If your lordship allow me, written argument, my lord.
Appeal. Dismissed.
so obliged.
Item 5,
खाली पार्टी का नाम ले लें.
Obliged, my lord.
Dismissed. Only on that point, Ms. Allen,
Yes.
because that has been the norm. Will not change it. Yes.
My lord will just take LICI Act for a moment, Life Insurance Corporation,
Yes.
because the regulation that has been come into force is virtue of the LICI Act. Now, my lord will take into first. Just try to satisfy your lordship.
No, please do so.
First, section 21C.
2(1)(c).
Lordship. I'll be coming one by one.
1.
Chairperson.
2(1) is appointed day.
Chairperson,
Where?
LIC Act 1956.
No, you said provision 2.
Section 2 law.
Definition.
Definition, lordship.
Unfortunately, in this book, chairman is not there.
Chairperson means chairperson referred to in clause
4.
A of subsection 2 of section 4. My lord has got it.
Means here, this, I think, when was it amended? That amendment, it's an amendment. Just give me that. Not here. You have an LIC Act. We have an LIC Act. I just check. Here, this rules, this regulation, I think now it is called a rule. 1960.
Yeah.
I don't know. Once I downloaded something, I got 1960 rules.
1960 is the regulation.
No, that has been described as a rule in the one which I downloaded. This has never been used. I suppose. First time it is being used. Okay.
21C.
Hmm.
My lord has got it. Chairperson means the chairperson referred to in clause 2 of subsection 4. My lord will just now come to section 4 for a moment. Section 4. Board of Directors. Marriage. That is the general superintendence and direction of the affairs and business of the corporation shall vest in its board of directors, which may exercise, very important, your lordship, all such powers, very important, and do all such acts and things as may be exercised or done by the corporation. Now, lordship, for a moment, section regulation 48, my lord was just referring upon. Can I read regulation 48 for a moment in this context? I'll be just coming through. May exercise all such powers or do all such acts as may be exercised or done by the corporation, and are not by this act expressly directed or required to be done by the corporation by in a general meeting. Now, in a general meeting, now who are the board of directors? The board of directors of the corporation shall consist of the following directors, not exceeding 18, whom shall be one of the women, namely, one is the chairperson of the board to be appointed by the central government, who shall, during the initial period, be a whole-time director of the corporation. I mean, the chairperson is also the whole-time director of the corporation. After third initial period, be amongst the non-executive directors nominated or to be nominated by the central government. So this, now by virtue of this section 4, the corporation has the power by virtue of the general meeting to do all such acts, and which are not even vested in the act by a general meeting, which the corporation ought to do. Now, lordship, coming to regulation 48 by a general meeting. Regulation 48 says, notwithstanding anything. Now, lordship, for a moment, again, I'll take your lordship to section. Just one more section, lordship. I'll draw it to your lordship. Then I'll be coming to one more decisions. Oh. Regulation section 49 of the
Section
LIC
49 of the act.
of the act.
Right.
The power to make regulations. This is the by virtue of which the regulation has been framed. The board may, with the previous approval of the central government by notification in the official gazette, make regulation not inconsistent with the act and rules thereunder to provide for all matters for which the provisions is expedient for the purpose of giving effect to the provisions of the act. Now, the regulation 1960 has been framed, given effective by virtue of the powers conferred under section 49 of the LICI Act. Now, coming to regulation 48, lordship. Notwithstanding anything contained in the regulations, the corporation may, of its own motion or otherwise, after calling for the records of the case, review any order which is made or is appealable under the regulation. Now, lordship, for a moment, the termination order has been passed under regulation 39 of the staff regulation. The termination order is under regulation 39. Now, no appeal has been preferred by the petitioner, which is provided under regulation 40. Because as per,
Mr. Nandi, that is not the issue.
no, just I'm drawing to your lordship the facts of the matter.
39 is the
39
penalties prescribed. You will have to refer to that. The
39
only
is-
question here which you have to answer
Is it-
is whether it is to be done by the board or it is to done by the chairman. That's all.
Yes, now, as per LICI Act lordship, what? Section 4,
Chairman is not the board.
the chairman includes the board.
It's a part of the board,
Yes,
right?
yes,
Section 2, the definition, if you see the amendment also,
yes.
it's been amended also.
The chairman
Board
is,
is a combination of 18 persons,
yes.
with the one of them being the chairman. So he is not the board.
I'm not submitting
So
that.
how can he take that decision?
Yes. Now, what is the day the board shall, again I'm reading. What the board shall vest in its board of directors, which may exercise all powers. Now, the board of directors by a resolution has given the chairman to exercise. It is the board of directors has given.
No, that cannot be.
The board of directors.
You read that once more. Read
The
that
board
once
of directors may exercise all such powers
Hmm.
and do all such things which may be exercised or done by the corporation. Now, the board of directors by a resolution resolved the chairman to take appropriate action. That your lordship will kindly take into consideration. To that lordship,
So 48, you mean to say that even tomorrow the board can delegate that power to a branch manager here?
no,
See, this is a power you are using for review of enhancement of a penalty.
yes,
That penalty enhancement has to be done by the authority vested with that power, not with anybody else.
in consonance to regulation 4 also, lordship.
Regulation 4,
4, yes.
4 does not come in. 48 is distinct. It's a
48
separate.
is distinct and
separate.
regulation 4 says the chairman is the appropriate lordship for a woman.
Chairman, maybe, is the appropriate authority for all other purposes.
Yes.
But when you are using a power of review and that power being vested in the board,
Yes.
board cannot delegate that.
Lordship.
Simple. Any decision?
Yes, lordship. No, those. There is a decision, lordship, those not directly, my lord will just take into consideration. This is a very recent decision of our own.
You
honor-
see, as may be exercised or done by the and are not by this act expressly directed or required to be done by the corporation in a general meeting.
Yes,
In a
in a
general
general
meeting,
meeting, that,
general meeting means meeting of the shareholders. Shareholding pattern is there. LIC has a shareholding pattern.
lordship, in a general meeting, only the resolution was taken.
General meeting of the
57,
company. No,
5,
general meeting of the company, not of the board.
Lordship,
Make that distinction clear.
in a general, it is not specific whether.
No, it's specific.
No, lordship,
Company, it's a company.
lordship.
Then it will have a general meeting of shareholders.
No, it is in a general meeting, lordship, it is a general meeting of the board of directors because had it
Cannot
been a
be.
general meeting of
Cannot
the
be, Mr.
shareholders.
Nandi, it cannot be.
It is my submission.
It cannot be.
But-
Why do you make a submission?
Yes, it is my.
Just for
because
making a submission.
It comes within the periphery
You
of
want
the
to
board
know
of
you
directors.
want to have the answers? Wait, I'll just give it.
No, lordship, coming to the decision of the honorable, of our own honorable court. In this case also, lordship, the petitioner was dismissed from service. He preferred an appeal. He preferred a review application also. Going to the proximity of this offenses he has
What is the name
committed.
of the case? Case, what is the name? Party name?
K.R. Cardon,
High Court, our High Court.
our own high court.
Is given. Okay.
K.R. Cardon versus Life Insurance Corporation of India. He was dismissed from service under Stock Regulation 1960. He preferred an appeal. That was also dismissed. He preferred a review. That was also dismissed. Then he came before this honorable court, where this honorable court has held that going by the proximity of the allegations against him, this honorable court will not interfere. I'm just placing the submission, man.
Where is the issue of 48 here?
No, Lordship, I'm saying here I am referring to this judgment because the proximity of the allegation against him. That is the thing.
That is different. That is different. That who is denying the proximity or the allegations against him? Who is denying your power under review? Only I'm questioning the second part.
The second part, Lordship, as per section 4, Lordship, read with section
Okay.
48 and 4, the chairman has the ample power to review. That is my humble submission. As per section 4 of the LICI Act, read with section 48 and read with regulation 48 and regulation 4 of the staff regulation, the chairman is the authority to review on behalf of the corporation.
So, Mr. Nandi, your submission is 1,
Lordship,
chairman has the power.
by virtue of section 4 of this LICI staff,
Regulation 4.
by virtue of LICI Act 1956, read with regulation 48.
Which provision of LIC Act? 2.
No. Section 4.
No. Section 4 of the LIC Act.
Yes.
Or regulation.
It says section.
Section 4. Okay.
It says section. Regulations is.
No. Section 4 or regulation 4. That's what I was.
Section 4 of
Section.
LICI Act 1956.
Page 4.
My lord is
So
gone.
4(1).
Yeah,
right?
4(1). Because in a general meeting, the resolution was taken. Read with regulation 48 and regulation 4 of the staff regulation 1960.
Okay. Then?
Read with regulation 48(1).
Fine, got it.
And for regulation 4, because regulation 4 says the chairman is the authority to implement. That is my submission.
Yes, Mr. Goswami.
Lordship, it is clear cut, it is clear, very much clear that the chairman has no authority. It is clear. Section 4, it is a constitution of the corporation, nothing else. There are no any mention that chairman is the corporation. That is only a group.
And Mr. Nandi,
Lordship.
you agree to this proposition that the penalty was actually imposed by the chairman, although as per delegated power, and the board had not imposed that penalty. That would be your submission. But that penalty imposition is correct because under 4(1), the board can do anything it wants to do. It can require anybody. I think that's the.
Obliged, Lordship.
But Mr. A, no, like, yeah. You are appearing for all, Mr. Nandi. You are the standing counsel.
No, I'm panel.
What would let a counsel appearing for LIC?
Yeah,
also?
Lordship. Reserved.
Disposed of, we'll pass it after only during the vacations, holidays, I'll do it. You'll get it on 27 or 28.
Lordship.
Obliged.
6 and 7.
बाकी हो गया नहीं Please finish up the. Please not the. Admissions, not started. Not finished. No, finished admissions. I've told them after first finish admissions. Mister, let's just get over with the admissions. Then we'll come back.
Correct.
People are waiting for a long time.
Item 36.
Yes, Mr. Monto.
This matter very close because my lord, the as per the in view of the order passed by lordship on 14/9/2020, the only my lord, the grievance is already been mitigated and this is suffice to their my lord.
It is that matter, same matter.
Yes,
which
same
we are
matter. So,
arguing.
in view of that, my lord, this subsequent matter was my lord. done.
Here, I think you are in the clear.
Yes, well, so they have participated and they have been considered, so that is
Nothing is
before lordship to consider as something.
Mr. P. Monto, Learned Counsel, appearing for the petitioners, has submitted that the grievances of the petitioners have been redressed after in pursuance to the directions as passed by this court by order dated 14/9/2021 in the present proceedings. Accordingly, he prays that the present proceedings be not pressed any further. He would not like to press the proceedings any further. Accordingly, the writ petition stands dismissed as not pressed.
Mass obligation.
37.
Lordship, regarding similar issue, my lord, the matter is fixed on 2/4/24, my lord. WPC 5799, my lord. Regarding provincialization as Hindi teacher, my lord. Language. And that issue, lordship has fixed on 2/4/24 in WPC.
Same petition.
No, different petition.
I didn't get it.
My lord, regarding provincialization as Hindi teacher, my contention before you, this honorable court is that I'm a language teacher. Language.
You are a Hindi teacher, you say that I should be considered as a language teacher.
My lord. And in regarding that issue, my lord, another writ petition 5799/21, which is fixed on 2/4/24, my lord.
2/4.
2/4.
Idhar likha. This is item number
37.
37. Yes, madam. Are they not Hindi teacher, language teachers? Then he is senior to respond number 7. Respond number 7 is an English teacher. Anybody appearing for respond number 7?
No, my lord, in spite of
Notice.
service completed, he has not.
Mr. J. Loscott, Learned Counsel for the petitioner, submits that similar issue arises in the proceedings of WPC number
5799/21.
5799
My lord.
of 2021. And this court has fixed the said matter on 2/4/2021. Accordingly, he prays that the present writ petition be also listed along with the said listed on 2/4/2024. So prayer accepted. List this writ petition again on 2/4/2024 for further consideration.
Apply.
41.
Yes.
May I please lordship, lordship matter may be taken up first week of April, lordship. My
Why?
suddenly left the court, lordship, due to some.
Who is your senior?
Mr. D.A. Kayum, lordship.
Mr. Kayum.
Yes, lordship.
What happened? He's not keeping well. Anyway, maybe he's on fasting. On the prayer made on behalf of the petitioner, list this matter again on 3/4/2024.
Date, lordship. Oblige, lordship.
42.
Right, legal lordship. Case relates to non-payment of salary, my lord. Petitioner before your lordship says she is a headmistress of the Mulwa High School, my lord. And their school was regularized in the year
Yes, who is appearing for the government?
Mr. Sharma.
Mr. Sharma,
Till then, they have not received salaries, my lord.
you will have it.
It will be
Madam, where is your provincialization order?
lordships. That is page 14.
14. So this order they have not cancelled till now.
Yes, ma'am.
It's continuing. Something. Give the second file to Diana. Give the second file. Me. Huh? Where is the second writ petition? Copy of the second writ petition. Madam, just give me a copy.
Yeah.
Where is the second file? It might have got tied up with somebody, something, some cases, other cases also. Just check it.
Affidavit file করেছিলেন না? Affidavit.
Give him the affidavit, give him the affidavit.
Yes.
5, 6, 7.
My lord, there are 7, my lord,
Hmm.
in our affidavit, my lord.
Got it?
Yes, my lord.
Now you show me the power,
Yes.
act. You have act,
Yes, my lord. I have.
and the
My lord.
authorities of the department are under that act or above that act.
My lord, kindly come to the provincialization order, my lord. It's annexure B in our affidavit and my lord in repetition also there, my lord.
This condition is wrong. Where do you get this power to make this condition? Show me from the act.
My lord, in the order is, my lord, subject to the condition that there.
You show me-
performance and number of.
You
students.
show me from the act that this power is there. 30% particular period
Yes, my lord.
is the provision of the act. Now show me, beyond that also you can do. I'll ask Miss Devi to go home.
My lord, at least 25 students is required, my lord.
Why did you provincialize them then? Who asked you to provincialize them?
My lord, provincialized was.
You come to the
given on
Provincialization Act.
petition, my lord.
You come to the Provincialization Act.
Section 3, 7, lawsuits. Lawsuit can be under page 16, my lord. Why they have not been paid our salary? Because at the time of HSLC examination, only 18 students were appeared. But lawsuit kindly peruse the section.
Madam, take your seat, take your seat. Yes, come to 3-6.
6.
High school? 3-6, right?
Yes.
In case of a venture high school,
Yes.
higher secondary, so and so, the concerned venture must have consistent academic performance, which would mean that at least 30% of the candidates appearing for the final examination as a whole must have passed in the last 3 consecutive examinations held during the 3 consecutive years prior to coming into force of the Act. 17, 16, 15, let's say 14. How can it be beyond 17?
My lord, 315, my lord.
315.
Yes, my lord.
Okay.
The venture educational institution has a minimum total enrollment of 25 students in class 10. If it is a venture high school, 25 students in class 12. If it is a venture higher secondary school and or a venture junior college, 30 students in the final year of 3 years degree course. If it is a venture degree college, as on the date of coming into force of this act.
Fine.
So, my lord, here in
Show me.
petitioner's school in the 2021, they have less enrollment
21.
in 2021. Yes,
How
my
can you take 21?
my lord.
Mr. Sharma, how can you take 21?
As far as my lord provincialization order is concerned, my lord, here provincialization order, it is reflected that in pursuance of the letter so and so and a letter so and so, government of Assam and
This
in
is
accordance with-
a wrong prescription.
in my lord first paragraph in last line.
I know that. That is without jurisdiction. That is not sanctioned by the Act.
And here, my lord, specifically, it is mentioned that HLC examination 2021 conform.
How
to the
can you,
eligible
this is
standards.
done by that committee, a foreign body, not by SSLC, SLC, DLC, So release to them full salaries. And if they are not complying, if they are not teaching, proceed,
Yes.
dismiss them.
Hmm.
But you cannot take an action which is not sanctioned by the act. Tomorrow, prepare, tomorrow. Right? Tomorrow. Madam,
Yes.
madam. Slip करके रख दो. Just send it by slip. Let the file be here. Tomorrow. And you will find similar orders.
Yes,
Unfortunately, I was there, that's maybe.
yes, and I know.
My lord, a copy of writ.
Madam, give him a copy.
The copy is which Khatuniar actually. Khatuniar notes.
You go immediately, otherwise she'll not give you.
For orders, item 43.
May I please your lordship?
Hmm.
In this case, the petitioner approached before this court for provincialization his service under 2011 Act, my lord. Now that 11 Act is no longer exists, my lord, so matter may be infructuous in this regard. And he was left out from provincialization at the time of
We'll pass an order. You want it to be dismissed as infructuous?
yes.
We'll not do that. We'll do something better. Your services have not been provincialized till now? Ms. A. Buzarbova, learned counsel appearing for the petitioner. Also heard Mr. U. Sharma, learned counsel appearing for the learned standing counsel, secondary education department. Full stop. Ms. A. Buzarbova submits that in view of the Buzarbova submits that in the petition, the petitioner has prayed for consideration of his case under the provisions of the 2011 Act provisions of so and so. Full stop. The said act being in the meantime interfered, set aside and quashed by this court, she submits that the case of the petitioner under the provisions of the said act cannot be considered. Accordingly, she prays for withdrawal of the petition. Full stop. The prayer is accepted and the petition stands dismissed on withdrawal. However, the petitioner is granted a liberty to approach the respondent authorities by way of filing an appropriate application, praying for consideration of his case for provincialization under the provisions of the Act of 2017. So in the event of filing of any such application, the respondent authorities shall consider the same in accordance with the provisions of the, strictly in accordance with the provisions of the Act of 2017. I think that will take care of you.
Must have been.
With the above, I thought dismiss condition.
44 and 45.
My lord, before starting, your lordship kindly have a look the order dated 6 February, my lord, on the item number 45. There was a specific direction was given, my lord, lordship before.
No, Mr. Pukon is smiling. Some good development is there. Yes.
Has to be, my lord, as per.
No, I
the
told this
lordship.
junior that he should come with something very sweet.
Yes, my lord, as per the last order, my lord.
This is the resolution, you know. 28th February.
Process is complete, Mr. Pukon.
My lord.
Extra copy na hai, my lord.
Yes, sir. Then.
I like it. What happened finally? Okay.
That ratio is received, my lord.
Resolve that services of 34 C&D grade against another so and so be regularized with priority to the ones engaged appointed so and so effective from 1 April 2024.
No, my lord.
So Mr. Day's case is also covered here.
My lord.
No, my lord. Order is not this, my lord. Lordship kindly have a look, page 13, my lord.
Let them do it.
My lord, lordship has already passed an order, my lord, giving effective from the specific, my lord.
Huh?
Their entire case is regarding
597 page 11 be seen, my lord.
and this resolution
Page
is
13,
regarding
my lord.
regularization, my lord.
Page 13, my lord, if they so, my
Effective
lord.
from 11/1/2011.
Yes, my lord, 11/1/2011.
Fine.
If it is there, my lord, then.
No, I'm not on that. They have done something.
But done something,
they
my
are
lord,
doing
in
something.
compliance with the order of the honorable court. my lord.
That we are there. We will sit. We will see. But
Lord.
at least you get your regularization.
At my lord.
You
Lord,
get some money. Start getting some
Lord.
money.
at least.
How the orders of this court will be implemented, that is, leave it to us.
Lordship.
When can you pass the
Lordship.
orders? When will the orders be issued?
No, there is only one roadblock, my lord, that model code of conduct. If your lordship direct the
This
university
model
authority,
code of conduct will not affect.
The
otherwise we are ready, my lord.
My lord, model code
model
of
code of
conduct,
conduct does not apply to a university.
any university or
My
the
lord,
case. my
No,
lord.
no, it does not apply.
Does
How
not.
does it
The
apply?
judicial order.
No,
my
we'll
lord.
not pass a judicial order because problem.
Ah,
That will prejudice them.
yes, my lord. That
Because
cannot.
then they'll be bound by that. Why should I?
My lord,
Mr.
at least
PJ Fukan,
my
learned
submission
counsel.
may be
for the-
recorded that we are
No, Mr. PJ
initiating
Fukan,
the
learned. I'm reading.
regulation.
Mr. PJ Fukan, learned counsel, for the respondent submits that the process for the process for appointing the petitioners on regular basis is closed up. Mr. Fukan is directed to place on record the orders issued towards regularizing this, towards
Regularization.
towards granting regular scale of pay to the petitioners hearing within a period of 1 week. So accordingly, list this matter again on 5/4/2024.
Can it be on 14, my lord?
4/4/2024.
My lord, a copy of this, my lord, whatever. is-
So let it be with him on the next date. We will see.
My lord, instead of
I have
appointment-
also not seen. So I also don't know it's from 2024. I will see.
my lord, instead of that word appointment, my lord, it should be regularized.
Regulation.
As per the order of the honorable court, my lord, that, my lord, will cover, my lord, from effective.
Dictate. I'll sign, dictate.
Lordship.
I'll do it, don't worry.
And that item 26, my lord. It's covered.
Similar, Mr. Days. Mr. Day, something is happening. Wait for a week more. Item number 26. Huh? List this matter again
On 14.
on 4/4/2024. 4/4/24 delay. 26/4/4.
Most obliged.
So you should thank Mr. Pukan for his steps.
46.
But in this case,
Seen the office note dated. Lazima Court order dated 4/3/2024. Service on respond number 5 and 6 is complete. Accordingly, list this matter for admissions. These are orders, huh? Admissions after 2 weeks on a date to be fixed by the registrar.
deeply obliged.
47.
Please, Lord. This is the
That-
person ranked junior MLR has been in a provincialized. In fact, my lord, I have prepared a chart of the documents showing the various dates, my lord.
It's that 2 certificates.
Yes, my lord. Not
One,
2 certificates, my lord. I joined much earlier. Yes, my 2 certificates there,
Uh.
but that is of no consequence at all, my lord. Because otherwise also, my lord, he is ranked junior to me, almost 8 years.
Tilapara.
My lord, I joined in 1992, my lord. He joined in 2000. And both are language teachers.
Tilpukuri.
Tilpukuri, my lord.
I think we had heard this matter.
Yes, my lord, we heard the matter, my lord. Because on the God that day, Mr. Parubhai, my lord, submitted, my lord, that seniority will not come into the picture, my lord. It has to be, my lord. He says that it cannot be seniority, my lord. It has to be something else, my lord. That's what he says. Seniority is not the only criteria. That's what he perhaps tried to say.
Assamese and Arabic
In fact, both, my lord, has subjects.
language, even if we treat it as, yes,
Lordship, actually, Mr. Puya is out of station. Can be heard on another date, Lordship?
On the prayer made on behalf of Mr. A.R. Bhuyan, lists this matter again on 8/4/2024. It is observed that no further adjournment would be granted in the matter and the matter would be taken up for final disposal.
Declare by the Lordship.
48 and 49.
Mr. Soma, you wanted to file a rejoinder, you're not filing?
We have filed. We
Fine.
have filed rejoinder, we filed lordship, we have filed a IA lordship, that IA only lordship, I want to praise lordship. We have filed the
rejoinder has-
rejoinder also. We have filed the rejoinder. There is
The
the IA
rejoinder has
lordship,
not come on. court.
IA 826.
Yes, what is your prayer here?
It's a small prayer, lordship has read the brief, so I not bother.
Don't
Only a small-
presume, don't presume.
No.
No, Don't
I
presume,
have seen, I am sitting here,
don't presume. Yes, what do you want here?
restraining the opposite party from taking any coercive action against the. What happened?
Inquiry is
lordship?
complete, inquiry is complete.
Dependency, suspension is stayed. He was restored. He was doing in service. He was called to the office. Lordship, in this case, there is a problem. Some vested interest people are there in the department. So she wants that her husband be the principal of that college.
Who is the
That's-
private respondent?
Yes, private respondent lordship can see in the writ petition lordship. He is a respondent there. This is the respondent lordship. It is the deputy secretary and now she is a joint secretary there. Respondent number 4.
Any document wherein the name would be reflected?
You see, the
Okay, I got
is there. It is an admitted position lordship. It is
Yes, Mr. Das, what do you say? What is the stage of the inquiry proceedings?
It is going on, my lord. And
it is going on, but the lordship, for me, one person has appeared as a
That State Bank
yes
officer.
Yes, that
But
has
they have
been-
not accepted.
Now they have refused. In 3 days he appeared. They have allowed. He has participated. He has started. When they see that he is a
See, the question Mr. Sharma is raising is, does the IO or the EO have a power of review?
yes,
Naturally, it's not there. Once you are permitted. And what prejudice, what is this so
But
big
the-
thing happening?
But the official, my lord, doesn't come under as a government.
And if
official
they don't know
because
that,
SBI
change them. If these people, they don't know the official procedure, change them.
No, my lord, the section says that, my lord, it has to be a government official, my lord. And SBI is, my lord, SBI is, my lord, public,
Sector
PSP
undertaking.
undertaking, my lord, and public sector undertaking, and there is a difference between public sector undertaking and, my lord, this,
Who is the inquiry officer here?
now it has changed, my lord.
Who?
I'll, Madhusudan.
since 3-4 times lordship.
No, who is the inquiry officer? And who is the presenting
Now,
officer?
Lastly,
find
the secretary.
I, my lord.
Secretary.
Yes.
And the presenting,
Presiding is also a deputy secretary,
not lawyers.
not lawyer.
No,
So have you nominated somebody, Mr. Sharma, as your defense assistant after that? No.
That is under silence lordship. There is another repetition lordship. 5998.
Any stay there?
No stay, but they were supposed to file the affidavit. They filed the affidavit last date. Only now, after 2 years, now we have filed the reply. to that. Notice, there is a notice on the interim law. And they took time for last 2 years. On the last date, when the court said that we will pass the interim order, then they filed the affidavit on the last date. And now we have filed the rejoinder.
When is the next date fixed for the inquiry?
No date fixed.
No date has been.
No.
How many witnesses examined?
Not a single witness. No, lordship, that's my case. My writ petition is no list of witness, nothing.
Nothing.
my lord, can.
First writ petition, lordship, that is why my silence, lordship, any date,
Okay,
lordship fixed.
Mr.
Can
Das,
we have
when can we
this-
hear
This
this
is
matter?
not
Please,
maintainable.
We'll hear this matter. When?
I'll argue just now, even if my learned friend is.
After holiday vacation.
Immediately. But till that time, don't proceed.
No.
No, my lord, this departmental proceeding is going on, my lord, kindly have a page 32 of their IA, my lord.
32.
Yes, my lord. 17/2/2024 was the last date for his departmental proceeding. That was for evidence.
32.
17/2/2024.
Yes, my lord.
You come to the next page.
33.
33, my lord.
Heard Mr. S. Sharma, learned senior counsel, assisted by Mr. J. Deka, learned counsel for the petition, for the applicant. Also heard Mr. S. Das, learned counsel, appearing for the state respondents. Considering the issues arising in the present I as well as in WPC number 5998 and WPC number 44449/2020, this court deems it proper.
5998 is 2022.
22 and 449/44449/2020, this court deems it proper to take up the writ petitions for final disposal. Also, as consented to by both the sides, list this matter again on 9/4/2024
Lordship.
for final consideration in the admission column. Also, till the next returnable date, status quo as on today with regard to the departmental proceeding shall be maintained by the parties. Also, the above order of status quo shall be subject to review next week on the next date. Also, no adjournment would be permitted in the matter, and in the event any adjournment is sought by the petitioner, the above order will stand vacated. Likewise, in the event the respondents seek or an adjournment and don't appear, the matter would be proceeded without considering the submissions of the respondents.
In the meantime, no coercive action.
I have said status quo as on today.
He's working, my lord.
There seems something amiss somewhere. You check up.
Yes.
Something is not, the vibes are not good. We'll see.
Yes, sir.
Departmental proceeding, they don't have a right.
Yes, sir.
But if they can show malafide or something, we'll have to consider.
We have to, I will show. The wife of the incumbent principal is the officer.
50,
My lord, here the non-compulsory order, that is annexure 1 at page 15, my lord, whereby it was given the direction to the authority concerned to give the my lord to consider for the, I may be enjoyed the my lord pay scale.
Yes, Mr. Das.
And interestingly, my lord,
Mr. Das,
my lord, I
this
take-
order was passed on 10/5/22.
my lord, I will take his.
No. You,
No,
that's what.
I understood two document, my lord. In by one document, they earlier stated to the.
No, but we are violation of this order.
Yes, my lord. So there's.
The only requirement by this court was to consider his representation, pass a speaking order.
Oh,
Why does it take 2 years?
my lord, I'll speak.
Do it, we are fixing it, get the compliance order.
Yes. Either
Then he
reject
can
or-
also, he's also hanging, he can also then take further steps, right?
Yes, sir.
Mr. S. Das, learned standing counsel, higher education department is requested to receive instructions from the Director of Higher Education Assam as to the manner in which the directions as contained in the order dated 10/5/2022 passed by this court in WPC number 4262/2014 has been processed for compliance. Also, the above instructions shall be furnished by the Director of Secondary Education, Director of Higher Education Assam to this, to Mr. Das before, on or before 10/4, on or before 9/4/2024. List this matter again on 10/4/2024.
No, my lord, may I pray, my lord, because by the 10, I'll be not available, my lord. So
Your
before
junior would be here. Your junior would be here.
my lord,
Your junior would be here.
that's all. Master.
You have pointed it out. Contempt is between me and you. I'll take care.
Pass up.
52,
List this matter before any other bench without me. I can't take it up.
Yes, my lord. Obliged.
Munam to the
53,
Third, Mr. M. Khan, Learned Counsel for the petition. Also Perus, Mr. M. Khan, ISC. So, the interlocutory application has been instituted by the petitioners as applicants, praying for impleading three officials in the post of Secretary to the Government of Assam, Director of Secondary Education and Inspector of Schools, Hailakandi, as respondents number 4, 5, and 6 in the connected contempt petition. Perus the contentions as raised in the interlocutory application. I'm satisfied that the officials sought to be implemented as party respondents in the contempt petition are the officials now required to comply with the directions passed by this court-wide order dated 5/2/2019 in WPC number 7760/2015. Accordingly, the interlocutory application stands allowed. The officials named in para 2 are implemented as respondents number
4, 5, and
6 in the contempt petition number 396/2020. Contempt petition of the House. In view of the order passed today in IA number 2018/2020, a para 4 A1 to para 2, page 4, 1, 2, 3, court corridor. The following officials are implemented as respondents number 4, 5, and 6 respectively. Petitioner to file amended cost title before the registry. Full stop. List this matter immediately on filing of the amended cost title in the matter by the petitioner. If you file that, then we will issue notice.
54,
54, I need some time, lordships. We have already sought a report from the district lordship regarding the vacancy of the senior assistant lordship. And
On the prayer made, prayer on Mr. Chisti, Learned Standing Council, Department of School Education, list this matters again after 2 weeks.
Yes.
2 weeks on a date to be fixed by the registry.
Obliged.
Just wait for one more day.
Yes, will.
He'll see to that it is compliant.
55,
May I please, Lordship?
Hmm.
Lordship. Order of this honorable court at place 14, Lordship. And relevant place.
Yes, Mr. Yeah, representation has to be disposed of, considered and disposed of.
Compliant lordship. He has
Where?
been granted number,
You've granted?
AIS number.
No, Lordship.
No, he is not in touch with the client lordship. Lordship, kindly peruse. It was pursuant to your lordship's second order, lordship. Initially, because of the
7 days.
Yes.
7 days.
7
Yes, 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 yes.
It's 16, Lordship.
Full stop. Mr. P. Naik, Learned Counsel, representing the sole respondent, has placed before this court order dated 8/2/2024, issued by the District Mission Coordinator SSA Kokrajhar, allotting a dice code number to the petitioner school. Full stop. On perusal of the said order, it is found that it is in strict compliance with the directions passed by this court-wide order dated 10/1/2024 in WPC number 68/2024. Accordingly, the order passed being complied with, the contempt petition stand closed.
lordship copy was annexed to the petitioner also. Same.
This
Yes, Lord.
Lordship, it
Next
is
week.
not furnished to me, Lordship.
Chandan Kumar, I think.
not here, yeah?
Same page, next page, lordship.
No,
That the short lordship, dice code short, next page.
no, it's not here.
Lordship.
Lordship,
Mark 2.
Page 17, it stops.
Lordship, one table is, just now I produced one table, Lordship. Next.
This one?
Yes.
Huh.
Issued by the district coordinator.
I've recorded that.
Yes, Lordship.
But this is not a part of the contempt petition.
No, what I was saying, Lordship, one copy was marked to the petitioner also.
Okay.
but not.
Condon Roy.
Lordship.
Anyway, you take a copy from him.
My humble prayer, Lordship, I may be allowed to go through the same, Lordship, and matter may be adjourned for the later.
If he is made a wrong statement, he knows what will happen. It is between he and me. I'm satisfied.
Yes.
You wanted a code, you got the code. What more? The MI is pending.
No,
Material instruction is pending.
Lordship, regarding.
Material instruction is pending, or that also cleared. If material instruction is pending, we can require one more day, no problem.
In that case, I am also ready to. If that is.
See, these matters should not be dragged like this. Fine, you got your relief. Be happy.
56.
You want to amend?
Yes, my lord, because my lord, without amendment, my lord, I cannot pursue the
Yes, madam.
relief.
Serious objection. Amendment. Amendment, serious objection.
No, your lordship.
No.
Earlier, he does not inserted that
Heard
petition.
Mr. S. Nath, learned counsel for the petitioner. Also heard Ms. P. Das, MS P. Das, learned counsel appearing for the
Respondent
1, 2, 3, 4, 5,
3,
4, and 5.
1, 2, 4, and 5.
1, 2, 4, and 5. Okay. Heard Mr. You are for?
Number 8, Lordship.
Heard Mr. D, Ms. MS D. Das Burman for the respondent, the additional senior government advocate for the respondent number 3. Mr. Your name?
NZ Chaudhary.
N. Jet Chaudhary, learned counsel appears for the respondent number 8. You have no objection?
No.
The interlocutory application has been preferred by the applicant oblique writ petitioner praying for amendment of the writ petition in the manner as projected in para 4.1 and 4.2 of the interlocutory application. I have perused the materials available on record, and I'm fine that the said amendments would not change the nature of the writ petition. Full stop. Further, the counsels for the respondents have also not objected to the amendment as sought for by the petitioner. Full stop. Accordingly, the interlocutory application stands allowed. Petitioner is permitted to make the amendments as indicated in para 4.1 and para 4.2 of the set of the interlocutory application. Full stop. The petitioner is to file an amended writ petition incorporating the amendments as allowed herein above. With the above directions, the writ interlocutory application stands disposed of. So main writ petition. In view of the directions passed today in IAC number 864 of 2024, permitting the petitioners to amend this writ petition in the manner as indicated in para 4.1 and para 4.2 of the said interlocutory application. Stop. The petitioner is directed to file the amended writ petition within a period of 3 weeks from today. Registry to list the matter after receipt of the amended writ petition.
DPO list. 58 of the supplementary list.
Here in this case, my lord, there is a office note, my lord. I have to take step, my lord, to respond 6 and 7.
Mr. H. Das, learned counsel for the petitioner, submits that he be granted 3 days' time to take steps upon respondent number 6 and 7. Also, prayer allowed. They list the petitioner, prayer allowed. List this matter again after 4 weeks, along with a report with regard to the status of service of notice upon the respondent number 6 and 7.
59,
Please, your lordship. My lord, the opposite parties have filed an affidavit in opposition yesterday.
Hmm.
I will file a rejoinder 10 days time.
Lordship, may I submit, may I get 2 minutes of time, Lordship? Lordship, this IA of similar fashion was, Lordship may kindly come to page number 70 of the affidavit in opposition that we filed. So Lordship, that particular order happens to be the order.
The
against-
affidavit filed by degree holders,
Yes, the degree holders.
page
70, Lordship, 70 onwards.
71.
Yes. So Lordship, an IA of exactly similar fashion was filed by them, which was dismissed in limine by this honorable court.
No, it was withdrawn by us, man.
That was dismissed on withdrawal with the remark that since the stay order has been vacated, that cannot be interfered with. And Lordship, the IA that has been filed now, the ground that is taken is that we have not furnished the invoices. Interestingly, that has been concealed by them. So far as this IA is concerned, they had annexed the invoices in that particular IA.
The earlier IA.
Yes.
Yes,
Lordship.
madam.
2945, if that particular IA is there. Lordship, 2945 of 2023.
Yes, Mr.
Lordship,
Gogoi.
My lord, actually, my lord, they have furnished only, my lord, February and March, my lord, invoices, my lord. Not from the September. My lord, payment was from September 2022 to, my lord, March 2023, my lord. They have furnished only 2 invoices, my lord.
Lordship, may kindly say-
Thereafter, we could not proceed with the payment due to, my lord, GST issues, my lord. And still we are ready to pay. Now only on lordship come to the page, my lord, page 46
So,
of the
yeah, we
IA.
are proceeding with the hearing.
Huh, my lord?
You don't want to file an.
No, we will file, my lord. He
Then
is
you
ready.
file that, we will hear it.
My lord.
We'll hear the matter.
Lordship, my only apprehension is that the movable properties may be liquidated. This is merely a.
It is their
No,
property.
that is
That is a rented
Since
house, my lord. Our office.
attachment of immune against items so and so be kept on abeyance till consideration of IA. Also, will direct that you will not
My lord.
Lordship.
alienate. Your name?
Y. Kothari.
Mr. Y. Kothari, learned counsel for the respondent opposite parties,
Lordship.
has submitted that the affidavit on behalf of the said respondents has already been filed on 19/3/2024. Also, Mr. Gogoi, learned counsel appearing for the J.C. Gogoi, learned counsel appearing for the applicant, has submitted that he be granted 10 days time for referring the rejoinder to the objections filed by the respondents. So, accordingly, let's this matter again on 19/4/2024. Also, it is provided that in continuation in terms of the directions passed by this court by order dated 6/3/2024, keeping in abeyance the order dated 1/3/2024 passed by the learned trial court, right?
Lordship.
Comma, it is provided that the applicants herein shall not alienate the property involved until the conclusions, until further orders from this court. Right?
And my earlier interim order may continue.
Mr. Kothari further submits that
59.
in view of the interim directions passed by this court, white order dated 6/3/2024, there is an apprehension that the applicant's hearing would alienate the property, suit property, full stop. Uske baad, till that next date, without, should not alienate the property without leave, without further, shall not alienate the property till conclusion of the present proceedings. Right? Without further leave of the court. Further conclusion, further proceedings, somebody withdraws this matter, then it's gone.
Lordship.
Fine.
Deeply obliged.
6 and 7.
Yes, Mr. Khan.
Hello.
You have made that list.
My lord, I have prepared. My lord, if your lordship allows me one submission, my lord, my humble submission is, so far as my lord, the petitioner in other case is concerned, at best, my lord, he can have a claim against the client of Mr. Khan. My lord, now having accepted by the initial, my lord, provincial letter that he belongs to language teacher, in the earlier proceedings, he did not object, my lord, he belongs to my lord, language teacher. Now he cannot change his stand, my lord. And my lord, my humble submission is, since my lord, even if my ouster will not give him any benefit, he cannot claim my post, my lord. So therefore, my lord, my respectful submission is, so far as my provincialization is concerned.
We will dispose of both the matters together.
The lordship will dispose it of. My lord, what I'm trying to submit, my lord, since my lord, my provincialization does not, my lord, make him suffer, my lord, legal injury. So therefore, my lord, he is not an aggrieved party in respect of my post, my lord. My
We'll
lord,
see.
lordship, yes, I
I
place,
got it.
my lord, this judgment, Ayub Khan, my lord, Nura Khan, lordship will only take note of paras 10 and 17. Unless there is a legal injury, how can he challenge, my lord? He is not aggrieved in respect of my post, my lord. At best, he can have a claim, my lord, A to D devotion.
My lord, I have collected some document, my lord, regarding the, my lord, routine, daily class routine. Daily class routine shows that the, my lord, petitioner, even, my lord, he was a headmaster, he is a headmaster, he also regularly attend the classes. So which shows that, my lord, he, my lord, taught, my lord, the language English teacher.
Who has prepared that?
My lord, is the, my lord, president as well as the, my lord, headmaster.
He himself, my lord. He is the
No, my
president,
lord,
headmaster.
no, my lord, it's the regular routine followed by all teachers.
All documents manufactured by him or for his convenience.
And I have given the.
See, there is a finding
My lord.
by this court. You have not gone on appeal.
My lord, liberty was granted to file application. I have filed application, but my application was not considered. And the honorable court in earlier proceeding, my lord, did not give any specific opinion to anyone, my lord. Kindly see the, my lord, findings of this judgment, my lord.
List this matter on 1/4/2024 for delivery of orders. Give a small note, whatever you have to say.
And in the,
Sir,
in
you have given.
my affidavit in reply against the direct.
Fine, I just indicate that.
My lord.
Just indicate that in your that one page note.
And two judgment, my lord, I would like. to-
Whatever you have to do. Whose handwriting is this, Mr. Talukdar?
My lord, lordship perhaps ineligible, my lord. I
No,
will
no,
type
it's
it up.
good.
My lord, my colleague, my lord.
One thing, my lord, can you
Vinay.
see page, my lord?
Vinita Bonia. In fact, I have put my signature, but she ought to have put it.
No, it's good.
Because his name is not in the Wakala now.
No, fine. It's when I.
My lord, page
Nice.
43, my lord,
Clear.
resigned by the, my lord, Sapir, he was resigning.
When you see something better than yours,
Yes, correct.
it gets attracted.
Correct.
They
Very
face
good,
a lot of
like
problem
typing
because
out.
of my thing.
Yes.
Now
I
they are
also-
trying to decipher.
I have also seen like typing out
Maybe my
something.
handwriting, I think maybe it was that I have to be a doctor, but.
My lord, one thing I may be allowed to point out, my lord.
Uh-huh.
My lord, page 44.
Hmm.
Sapir Islam, respondent number 9.
Hmm.
He was resigned from the, my lord, from the service, my lord. Then he was again reappointed when I was promoted to the headmaster.
What did you write in your, that application form you submitted? You have to submit an application
Yes,
form.
yes.
What did you write there?
My lord, as per the, my lord, direction of the honorable court, my lord.
No. Initial regularization, provincialization.
My lord.
You have to submit a
Yes.
form.
Yes.
What did you write there?
My lord, he write, my lord, in the first form, he write, my lord, I was appointed in, my lord, 1993. Then the
My lord,
second
page
form, my lord, it was
122,
wrongly.
Where we have the forms with you.
My lord, page 122, my lord.
My lord,
This is the form available in the office also, my lord.
122 of which one?
My lord, he's a
Which?
The reply of the private respondent, my lord.
No, which petition? 4881 or
4564, my lord.
4564? Page 122.
122, my lord. Third column, my lord, date of joining 12/3/2002, my lord.
No, my lord, is a my lord, date of joining as a headmaster. My lord.
No, madam, we are fixing it on one. You get those application form. You remember in one of those matters you had brought it for me.
My lord,
The application, in each one has to submit a form.
my lord, my lord,
Get that.
my lord.
Miss Miss S. Chutia, on the next date shall also on the next date fixed, submit the individual application forms filled up by the petitioners as well as the respondent for provincialization of their services.
My lord, initially Lordship said for delivery of orders. My lord, my prayer is, my lord, my writ petition may be disposed of, my lord.
No, we'll dispose it off on that day.
Yes.
I just want that form. Let them get that form, we'll.
Because initial, my lord, provincial and letter, your lordship will see, provincial order. My lord, that showed him English. He did
Mr.
not say,
Talukdar,
yes. My lord, what I'm trying to say. My lord, he is pulling my legs without any reason, my lord.
No. Let the better things happen.
My lord, my lord.
And don't worry first. It's
Correct,
only that,
correct.
only that,
No. What
only
I
that
want,
name,
my
but
lord,
otherwise first, everything will not be bad.
my lord,
It's only the day,
my lord, my lord.
1st of April.
So, my lord, for-
April,
yes.
only for them. Otherwise, don't worry, it will be done.
My lord, in page 122.
You give me a note,
My lord,
okay? And anything you have to say,
my lord,
10 minutes before delivery,
my lord,
allowed. All.
my lord.
And Mr. Talda, relax.
No, my lord, I'm relaxed, my lord, but in fact, my lord, he is unnecessarily dragging my case. My lord, what I'm proposing,
When both these cases are there,
yes.
you don't worry,
Well.
we will do the work.
On first, my lord, for delivery of orders.
Delivery of orders in
follow-
both cases. We'll pass orders
My
on
lord,
that.
obliged, deeply obliged.
I'll also have to think about them.
My lord.
Everything if I reserve,
No, I'm not
it
interested.
will not
my
be,
lord. Correct,
it will not be possible for me also.
correct.
So I put it on first, I'll pass the orders in court on that.
My lord, obliged.
14,
Not can I submit today or my lord on that?
May I please, lordships. In this case, my lord, I would like to withdraw the case, my lord, with a liberty to file a fresh, my lord. And otherwise, my lord, some in contentions has been not made in the
Sorry.
petition, my lord.
Sorry,
So, with a liberty to file fresh.
you're not permitted to bench hunt.
Otherwise, I have
you
I have to
proceed.
take some instruction, my lord, and sometimes may require, my lord. 2 weeks time, I will collect some judgment, my lord. Today I was trying, my lord, but could not collect, my lord.
You want to make
41st.
submissions
Yes,
on this. You
Yes.
want to collect for that, you want time.
yes, my
Why
lord.
not? Likho.
So, 2 weeks, my lord.
List this matter again on 2/4/2024 as a partner item.
Yes.
On the prayer of the learned counsel for the petitioner, list this matter again on 2/4/2024 as a partner matter.
Yes. Much obliged, lordships. Obliged, my lord.
item 24,
Yes, madam. Everything is done. Your principal has written that all the things have been shifted out. Anything left here now? Nothing.
no,
Ms. S. Bora, learned counsel for the petitioner, submits that the respondents, number 9, has dismantled and removed the construction available in the land of the petitioner school, and accordingly, the petitioner has no further grievance in the matter. Full stop, right?
Right.
In this connection, it is to be noted that Mr. S.R. Rabha has also placed on record a communication of the president, Gyanodaya Jatiya Vidyalaya Sevashram, no. Of the headmaster, Sevashram Girls ME School, Batabari, wherein he has contended that the respondent number 9 herein has vacated their occupancy from the land of the school. Full stop. In view of this set position, no live issue being, there being no live issue for a discussion, for a decision, for adjudication, the writ petition stands dismissed as being infructuous. Right?
my lord, this was, my lord.
Is disposed as being infructuous.
Highly obliged.
The communication received produced by Mr. Rabha, learned standing counsel, PTC, is kept on record and marked as X for identification. Right?
My lord, one thing, whether now respondent will pass any order regarding they have.
That I don't know. You wanted compliance?
My lord,
Only that much was your prayer here, or there is something more? Wait.
to restore that position. Page 13.
That is with you only possession. They were occupying, they have gone.
Yes.
What more is left? They had encroaching on your land. That encroachment is gone. The land is free for you. If you have any further grievance, go ahead. Do what you want.
Highly obliged, ma'am.